Okay.
Ready? Okay, so I'd like to call this meeting to order. It is 6:08. The first item on the agenda is a motion to approve the agenda as presented. Can I have that motion? Adam, in favor? Opposed? It carries. Lisa? And so the next item, I don't actually have the agenda in front of me. So the next item is to go right to land use bylaw review. Is it not, Riley?
Yes, it is. Yeah.
Okay. So can we continue with that presentation then, please?
Okay. Yes, Madam Chair, thank you. So I will be passing it over to Jill here momentarily. I just wanted to take a minute to say thank you for coming tonight and making yourself available for this meeting and allowing us to present the bylaw to you. Given the weather, man, it's super nice out. So we appreciate the time on such a nice evening. So thank you. Also would like to mention a lot of time and effort. We're really actually quite happy. We were talking about this earlier, but we're really happy to be in a position to present the bylaw in its final form. It has been presented to the CPC before in previous sections, non-residential and residential sections, and we're happy to now provide that to you as in its entirety as a complete draft. A lot of time and effort has been put into this by Jill and Joelle and the team. Yeah, we're just really pleased to be in a position now to present it and to have some discussion with you tonight and to receive your comments. Jill will be, I think, going over a bit of the past process, but also the process moving forward. So with that, Jill, I will pass it over to you.
Okay, so Riley, I was going to talk about a point of clarification with the process, but if Jill is going to address that, then we'll just proceed.
Sure. Yeah, and maybe I'll just take a second to do that. And I see Mr. Parsons has his hand up too. And so tonight is the draft bylaw. It is not the final or proposed bylaw that will be presented to council. So tonight it is being presented for your comment, and that is really more for administration's benefit, so that the comments that we receive tonight will take under consideration and then make any final tweaks before it is presented to council in its final form or the proposed land use bylaw. So it is not the proposed final version that will form the bylaw. It is the final draft that is being presented tonight.
Right. So with that point of clarification, Riley, just a clarification for the committee is that we won't necessarily be putting forward recommendations, comments, suggestions to council at this time.
That is correct. We will be gathering your comments on the draft. It will form part of the overall comments that we have been receiving for the overall engagement so far. So CPC's comments will be form a component of that, but they're not the comments that you would be providing in a formal sense on the formal bylaw once it is finalized.
Okay, thank you. And you said that Adam had his hand raised. My screen doesn't allow, oh, there's a chat. So.
Yeah.
So
I just wanted to say thanks to Jill and Joelle too. After watching all of those hours of video from, I feel like I was part of council, going through all that. So that was a lot of good detail. Thank you.
Okay.
And Riley too. You put in a good chunk there too. Thanks.
Okay.
Thanks, Adam.
Yeah. Okay, and I do see in the chat that Heather has a question.
So to that same part of the process, so now we're giving our feedback to administration, And then, am I correct in assuming from what you said that after the final draft is complete, then we would make a formal, we would have a formal voice with council?
Through the chair, the formal voice through council is, so the bylaw, all bylaws that come before council are referred to the Cochrane Planning Commission for comment. So the final land use bylaw or the proposed land use bylaw will be no different. So the final land use bylaw will be presented to the Cochrane Planning Commission after it has received first reading by council. And then those comments will then be provided to council directly at the public hearing.
Gotcha. Thank you.
Okay. Okay. Ms. Hoffer, I think that we are ready to proceed. Thank you.
Awesome. Thank you, Madam Chair. Welcome to our presentation. We really appreciate you guys taking time out of such a beautiful day to come and listen to our presentation on such an important bylaw for the town. So before we get started, there are a couple new members, and I just want to take a minute to introduce ourselves as the project team. So we have Joelle Anna Carrico. She wants to wave. I'm sure you guys can see her. She is our planner one with the town, and she has been working on this project since the beginning. About 3 years ago, she started with the town. Riley and Joelle were working together on this project. And then Riley became our planning manager. Yay. And then I began my role with the town of Cochrane about 2.5 years ago now, and I took over project managing the project from Riley. I am the current senior planner and project manager for this land use bylaw review project. So before I get started here today, I did just kind of want to clarify a few things. So we will be touching on some of the things that we have presented in our previous sessions with CPC. It sounds like a lot of you guys have tuned in to our sessions with council, and that's great. Some of the things like the districts, we're just going to be doing some brief overviews on them just in terms of time. And then we will pause occasionally. And because I'll be sharing my screen, it can be a little bit difficult for me. So if you guys do, to see if there's a comment in the chat. So if you guys have a question, just feel free to type question in the chat, and then either Riley or Joelle will interrupt me, or I'll pause and they'll kind of ask the question, just so we're kind of asking questions throughout, because it's good to ask the questions as they arise. You can always save them for later, but we just want to make sure nobody forgets them by the time we get through our presentation. All right, so if we get started here, I'm just going to go ahead and share my screen. All right. Can everyone see my screen now?
Not yet, Jill.
Oh, there we go.
There we go. Yeah.
Okay, perfect.
Just wanted to interject something here. If you guys see me looking to the left, my left, maybe you're right, I don't know. It's just that I have a very large monitor over here that I want to be looking at this presentation on. So I am paying attention.
Awesome, sounds
Thank
great.
you, Heather. I wish I had a very large monitor also. I have paper everywhere.
All right, so here we go. Here is our, it's an exciting night. We're so excited to be presenting our draft land use bylaw to CPC tonight. So thank you again for participating. So just a quick look at our agenda for tonight. We're going to take a look at our project vision and goals, how we got here, how did we get to this point in the project, our previous engagement with CPC, and some of the notable highlights for the bylaw. I think some of you guys probably noticed the parking lot session with council, and that some of you guys probably will want to talk about some of the things that came up during those sessions. We also have a few other new areas within the land use bylaw that we've added since our last engagement session that we are going to be talking about here tonight as well. And then our last thing that we'll be taking a look at is what's next for the project. When will we see you guys again? When do we anticipate going forward to council? And just any questions that you guys might have. All right. So at the beginning of the project, we decided it was very, very important that we established a project vision and goals for the project just to ensure that we were staying on track and mindful of what we were trying to accomplish through the new land use bylaw. So our project vision is a user-friendly document made for Cochrane that simplifies the development process, responds to modern trends in development, and creates flexibility for future growth. So the key part of this project vision is the for Cochrane component. There are things that you'll see within this bylaw that you won't see anywhere else. It's really special. We put in a lot of thought into how we can create something that was specific to Cochrane. We'll kind of touch on some of those things through the admin section and through some of our districts coming up. So for the project, we have a few goals that we did establish. So the first goal was to reduce red tape for residents and stakeholders, align it with existing town policies and provincial regulations. And so that's very, very important. Our current bylaw was adopted back in 2004. And so if we think about it, since 2004, how much has Cochrane grown? It's grown significantly. And so since this bylaw was adopted, there's been numerous updates to provincial regulations, and there's also other town policies where we kind of see some contradictions. So we were being really mindful that when we're bringing this bylaw forward, we also want to make changes so that all of our bylaws that overlap with one another also reflect the same things as the land use bylaw to help residents of Cochrane know and how to follow rules. All right, our third goal is to improve readability and enhance online bylaw presence. So I don't know if anyone had the opportunity to take a look at our draft bylaw, but what we have put together is quite unique. Each district has a figure, and the figure has different measurements, and they correspond with a table to help show users where these measurements are taken. These are just meant for demonstrative purposes, of course, but this is something that is very unique to bylaws in Alberta for sure, and in other places in Canada. So the fourth regulation is to modernize regulations to reflect current development trends. So as I mentioned previously, our current bylaw was adopted in 2004. You know, quite a bit of time has passed since its adoption, and things have changed. Development has changed. The way business is done has definitely changed. So that was definitely one of our main goals. And our last one, last but not least, definitely was to highlight the importance of the historic downtown. And we have done that in a few ways. And one of the most significant ways that we've done that is we have created a district specifically for the historic downtown. Currently, the downtown is covered within the central business district. However, that district covers other areas in town as well. So we just wanted to make sure that that area had its own distinct district because the development within that area is unique and is quite a bit different than other commercial areas within town. All right. Does anyone have any questions about the project vision or goals? All right.
Oh, I think you're good, Jill.
Sounds good. All right, just a quick look at how we got here. So early on in the project, Riley had actually put together a project management plan, and this project was divided into 5 phases. So phase 1 was project startup, which included the creation of the project management plan and engagement plan. One thing that's very important to note about how this project management plan was drafted was that public engagement and stakeholder engagement was at the forefront. So there's been a significant amount of engagement done throughout the project. I'll also kind of touch on some of the unique things that we did do to make sure every landowner in town was notified that this was being done. That was extremely unique to Cochrane in a few moments here, but phase 1 was essentially establishing the project and the project management plan. Phase 2 was reviewing the current bylaw, engaging with the public and stakeholder groups and the planning commission, and then reporting on the findings. I began work on this project near the end of phase 2. So I reviewed all of the engagement and public feedback that was received during phase 2, and we put together a report. We looked at the common trends of what the engagement essentially said, what residents' concerns were throughout Cochrane. And then we dove right into phase 3, which was researching and coming up and establishing options to help address some of the issues that were identified during phase 2. We are currently in phase 4, which is drafting the land use bylaw, consulting, and establishing the final draft of the land use bylaw. Through phase 4, we have done 2 sessions with the Cochrane Planning Commission, and now we have our draft bylaw that's been established, and that's essentially what we're here to present to you guys tonight. And phase 5 is bylaw adoption. So that is essentially the process as it goes to council. One of the things I did want to mention about phase 4 was we were really strategic with notifying property owners that there is a new land use bylaw that is being considered, and that there's a comprehensive review of the current land use bylaw. And I've actually been a part of a couple different land use bylaw projects in my previous life. And one of the main concerns from landowners during those previous projects were that they weren't notified. So what we actually did was we did a mail drop with our utility bills in May, and each utility bill, every single landowner was provided with an insert that did describe the project and did direct them to the Let's Talk page to take a look at what their properties and what their zoning could potentially be changing to through the adoption of this bylaw. All right, does anyone have any questions?
Jill, yeah, there was a couple of questions that come through the chat. The first question was around the target date for adoption. I did reply that we are currently targeting July for adoption. Also realizing that that is right around the corner, but we are still targeting July. And then Heather did ask, how many readings will there be of the final land use bylaw?
Oh, that's a great question. This document will require 3 readings, and we are in discussion with the CAO and our Legislative Services Department regarding the number of public hearings that we will be holding for it. So our public hearings won't be held on the same night as council. There will be special meetings scheduled for them. And we're currently determining whether it'll be 2 or 3 public hearings that will be held for the document. It is such a significant document, and we just want to allow for enough time for the public to be able to provide any input that they may have.
Jill, may I ask a question? Because with COVID, I'm just wondering, is there any discussion or ability, do you think, to be able to have any of those engagement sessions in person, or will they all be via Zoom sessions?
Jill, I can answer that. There is, I believe, a plan in place, and this is going to be dependent on the province and the phases that are coming through the province with related to COVID, excuse me. And if the phases go as scheduled, then council will meet in council chambers. So there is potential that council might be meeting and those might be open to the public. But that is going to be dependent on how we as a province progress through COVID this month.
And I think, Deb, they're looking at targeting mid-June for council as far as I know, but Riley is right that it'll just depend on what the province says for that.
Yeah.
And that will be in council chambers, so there won't be a public one such as in the other meeting room that's in the building?
That's correct. It would be in council chambers, correct? Yeah.
Okay, thank you very much.
You're welcome. Jill, Heather has asked, how will we let the public know about the public hearings?
That's a great question. So we will be advertising it in the newspaper. We are required by our advertising bylaw and through the Municipal Government Act to advertise it for a minimum of 2 weeks. But what we're actually going to allow for is we're going to allow for 30 days. So it's going to be an extended period of time for us to give that notification. So we're going to be doing newspaper ads, online advertising for that. And we'll just check on our timing, whether we can also do another mail drop with our utility bills again.
Sorry, Jill, can I ask another timing question? So if things are delayed for whatever reason and it goes into, we'll still have July. Sorry, I was thinking that we only had 1 month, but we have 2. So I'll send my question at the moment.
That's a great question, though. That kind of made me think about, when CPC might anticipate to see the final draft, and that's likely to happen in August. So you guys it'll be once it gets first reading, which will hopefully happen in July. You can anticipate that we would be looking for a meeting date to go through the draft or the final draft of the bylaw in August.
There's another question from Heather. Please go ahead.
So I'm just confused because we're going to do the first reading and our adoption target date is July.
Oh, sorry. And I think I can provide a little bit of clarity on that. The adoption process begins. So first.
Okay.
Sorry.
Sorry.
So we're projecting probably towards the end of July, mid to end of July for first reading at council. And then it becomes an official bylaw that council is considering. We're going to put it out to the public for 30 days. Right now, all of these timelines, of course, are kind of contingent on a number of things, but this is what we're projecting and what we're really hoping for. And then we'd anticipate first meeting in September for second and third reading, with the public hearing being held towards the end of August once the 30 days has passed.
Okay, Jill, I think you're okay to proceed. I don't see any other questions.
All right. So before we get into some of the information that we will be going through from the bylaw, I just wanted to take a look at some of our previous engagement events. I know that we do have a number of new members. I think Deb probably remembers some of these events. So back in phase 2 on August 21st and September 20th, Riley and Joelle held a meeting with CPC to kind of talk about some of the issues with the existing bylaw. And then during phase 3, we held a public workshop, and I remember Deb was at the workshop. It was down at the church.
Yes.
Where we looked at some of the solutions that we had been proposing to help address some of the parking issues that had come up in residential areas, talk about accessibility. And then we held a number of pop-up engagement events where a number of CPC members came out to visit and chat with us about the options that we were presenting on. And then, of course, earlier on in this phase, on August 26th, Joelle and I presented the residential districts to CPC, and on December 9th, we presented the non-residential components of the land use bylaw to CPC. All right, so now we will start talking about some of the notable highlights of the draft land use bylaw. So as we go through the administrative section, this is a really important section of the land use bylaw. This section establishes the provisions for development applications, development authorities, which CPC is one of the development authorities in Cochrane, amendments to the bylaw, and enforcement of provisions of the bylaw, among a number of other things. All right, so in Cochrane, we currently have 2 development authorities, and we actually have the opportunity for a 3rd development authority under our current land use bylaw, and that is through the direct control districts. So I will talk about direct control districts in a few slides from now, but essentially, the 3 development authorities in Cochrane, and the 2 main ones are the development officer and the Cochrane Planning Commission. The third one can be council, and that can only be in a direct control zone where council decides that they want to maintain the development authority of that district. And that's, again, that's only in a direct control where they want to maintain the authority. Where they might do that is on a very high risk piece of property, or where there's something very controversial, and then that would be a public process. And when there is a direct control application, those applications cannot be appealed just based on the district type. All right, so one of the unique things with the proposed bylaw that we are currently proposing is that each district contain a list of permitted uses, which under current bylaw, the development officer has authority of all permitted uses. And then we're proposing to divide discretionary uses into discretionary uses and discretionary uses under CPC's authority. Some of the things that you'll notice about this particular change is that we were really, really meticulous when we listed uses under CPC's authority. We wanted to ensure that CPC was reviewing applications that could potentially be perceived or that could be controversial in the community. So this is just showing an example of some of the discretionary uses that we are proposing under CPC's authority. So this is from a residential district, so residential high density. You'll notice under discretionary uses, there's bed and breakfast, childcare service, home occupation class 2, a mixed use building. So that's essentially an apartment building with some retail or commercial space just on the main floor. And then under CPC's authority, we're proposing a community facility, which could be something like a hall or a church or a religious institution, and supportive housing, which we'll talk about in a couple slides. Generally, these uses could really cause neighbors to be concerned. And so we wanted to ensure that there was that additional public process being completed for these uses. And it just depends on the district, which uses we've gone ahead and proposed under CPC's authority. One other thing that I did want to note is that while these uses are listed under CPC's authority, that doesn't necessarily mean that the development officer won't refer other applications outside of those uses to the Cochrane Planning Commission. These are just ones that automatically require CPC's approval. The development officer has the discretion that they could even, if there's a permitted use and there are neighbors that, I'm just giving you an example, but say there are neighbors that kind of get wind of a new application coming in and it's still for a permitted use, it's still allowed under the bylaw. If the development officer wants to allow for a public process or doesn't want to have that, doesn't want to have to make the decision on it, they can refer it to the Cochrane Planning Commission to have the commission make the decision on that. The other side of development authority, of course, is variance authority. So the variance authority that we're currently proposing is that the development officer will have full variance authority for all standards except for height, lot coverage, density, parking, setbacks to pipelines, and setbacks to escarpments. The reason that we've chosen to go ahead with proposing this type of variance authority and requiring that these applications go to CPC is generally these types of variances can cause more of an issue in the community. And so it was important to ensure that CPC has a second look. Of course, planning or the development officer prepares a recommendation and puts together rationale that is forwarded to the CPC, but things like height could potentially cause issues with neighbors, lot coverage, density, if you're trying to get more density on a site, or if you're trying to get less density on a site. We have plans to follow, area structure plans, municipal development plans, where these things are very important. And of course, parking is a big issue in our community. And so that was one of the main things that we heard throughout all of our engagement was regarding parking in residential areas. So we wanted to ensure that these applications for variances to parking regulations were being considered by CPC. Does anyone have any questions?
Hi, Jill. Yeah, there's a couple of questions here. I'll ask Chair Spence had a question about home occupation class 2. Deb, did you want to ask your question?
Yes, absolutely. I was just wondering if you quickly remind us, since, you know, with the newness of some of the committee members, what the home occupation class 2 represents?
Absolutely. So what we've actually done through this new land use bylaw is we have written a name change for these. So they're currently considered home-based businesses. And so we have a minor and a major. So essentially what we're doing for the new land use bylaw is a home occupation class 1 is replacing the minor, and a home occupation class 2 is replacing the major. The difference between the two is a minor is essentially somebody who has a home office. They're just working in their office. Maybe they're just having their mail sent to their house. You'd see like an oil fields consultant. There's really no on-site storage. There's no clients to the home. It's just an office essentially. A home occupation class 2 can include client visits to the home. So it would cover off like our massage therapists who work out of their home or people with hair salons at their place. They also require an additional parking stall for a class 2. One of the unique things for some of the changes that we are proposing to home occupations was many of our regulations are staying the same, but with the current pandemic and how people's workspaces have changed, we are now allowing for one employee to be able to be considered under a home occupation class 2. Of course, there would need to be a parking space for them provided on site, but it was just one of those timely changes where a lot of the stuff in the planning world is kind of predicting that there is, because of the pandemic, there is going to be a permanent shift in the way people work. So we just wanted to kind of be thoughtful and allow for that opportunity. Of course, it's discretionary. There are some additional things that they would have to do to be allowed to have that employee out of their home.
Thank you for that. A follow-up question is, with COVID and so many people working at home right now, how do you determine when indeed they need to have a business license?
I can answer that, Jill, if that's okay. If all people who are operating a business within Cochrane are required to have a business license. So if they are operating a business, then they are required to come to the town to make an application and then receive a business license.
I understand that. I'm just wondering if some people maybe don't understand because they've moved their business at home and just working out of home, that they actually understand that they require a license now.
Yeah, I'm not sure. We would certainly hope that they would come to approach the administration to ask the question. We are fairly closely linked. Planning services is with our business section and our business licensing, and anybody who does make an application for a home occupation and operating a business, we do inform them that they do require a business license with the town.
Okay, thank you. And it looks like Adam has a comment.
Yeah, I think there is a couple other questions in the queue though.
Prior to that, okay.
Yeah, so
Heather's first.
Okay.
yeah, I think, yeah, well, Heather, if you want to make a comment, and then George had a question as well.
Sure, and I might be getting a little bit of ahead of where we are right now, but when I was reading through the draft, there are certain instances in residential areas that we're no longer requiring a development permit to do, such as like remodeling, major repairs, that kind of thing. There were, if a person's doing that in conjunction with say a business or something like that, are they going to be required to get a development permit?
It will, so the short answer will be yes. So if they are operating a business out of their home, they will be required to get a development permit for the home occupation class 2. Now it will depend on whether they meet the definition of home occupation class 2 or if it is a class 1. But essentially, yes, if it is meets the definition of class 2, they would be required to get a development permit. Okay.
And then the next question that was leading into was that there are certain conditions or certain scenarios in development permits in the residential areas that don't require notification. And the reason why I think about that is because Jill, you said, if the neighbors get wind of, what you're doing and all that kind of stuff, is that there's not only some situations where there's no notification required, so they don't have to post a notification, but also situations where the development authority or the development officer could bypass the 21-day waiting period. So essentially, as a resident, I could have somebody have a permit approved and not know about it and start building or doing whatever without my knowledge until after it's already started. And I have a concern about that causing backlash. If we cut off that communication with people in the community, there's going to be backlash on, hey, we didn't know you were going to do this. Why didn't you ask me for my feedback? That kind of thing.
Okay, those are great comments, Heather. I'm gonna, Jill, maybe I'll respond first, and please feel free after. There's two. I'm going to start with the two types of classifications for uses within a zone. So zoning, there's permitted uses, and as you can see on your screen, there's discretionary uses. So in a residential area, the permitted uses that are listed, the way to think about those is that those are completely acceptable. They are 100% appropriate for the district and for to develop on that parcel. So as such, and also in accordance with the Municipal Government Act, all permitted uses, if they meet the land use bylaw, and this is where development rights are given to the landowner, they have a right to develop those permitted uses. So a good example is in an R1 district, in our low density residential district, a single detached home is a permitted use. And so whoever buys a property with that zoning on it as a permitted use, they have a right to develop that use in accordance with the regulations of the land use bylaw. And so given that in mind, there's a list of uses that don't require a development permit, and those uses are associated with permitted uses. Now, for discretionary uses, so discretionary uses are uses that can be appropriate for the property in the context of that neighborhood, but needs that extra assessment to ensure that it is appropriate for the neighborhood. So a good example is a place of worship is very common to have it listed as a discretionary use in an R1 district or in a low density residential district, but a place of worship may not be appropriate on every property. So let's say at the end of a cul-de-sac, for example. So it needs a little bit of extra review and attention to ensure that it is still appropriate and still meets the regulations of our land use bylaw. So in terms of notification, any permit that is applied for or is required to be applied for within the town, if it's a discretionary use, it requires a development notification sign. So that development notification sign it will be posted on the property, and that informs, it has information about what the development is being proposed for that site. And it gives contact information for the town. And it also has a link to our website and our map that lists all of the current development permits that are currently active as well. So that sign acts as the notification to the neighbors and to the neighborhood to let them know, and I'm sure you've seen them, they're the orange signs, that a development permit has been applied for on that property. So once the decision is made on the development permit, the development notification of the decision is also provided in the newspaper, and it is posted on our website as well. And the discretionary uses, also the immediate adjacent neighbors, and this goes for variances, for any application for a variance as well. Any direct adjacent neighbor also gets a letter from the town notifying them of the decision and their opportunity to appeal the decision.
Okay. Sorry, I'm just going to ask one last question on pertaining to that. So then does that 21-day waiting period, does the same thing follow? Does it follow suit that if it's a discretionary use, then no, the development officer can't bypass the 21-day waiting period? If it's just something that needs to be, notification needs to be sent out.
That is correct. So we are required to advertise the decision, and we do so in the newspaper as well as our website. And the notification letter goes out to the direct adjacent property owners as well. And so the 21-day period that you're referring to is the 21-day appeal period.
Mhm.
And so that is the opportunity for anybody in the community. Anybody can appeal the decision of the Development Authority, whether it's administration or whether it's CPC. They can file an appeal with the Subdivision and Development Appeal Board. And so your question was, can the Development Authority waive that? No, we are not able to waive the 21-day appeal period.
A follow-up question, I think, Heather, was there some place that there was going to be a change in the sign, the process for putting up signs going forward, or a suggestion that there might be? Did I read that someplace, or did I just imagine that?
Yes, there is actually some proposed regulation changes related to that. We do have a slide specifically for notification signs and we'll go through it in a couple moments here.
Okay, great. Maybe that's where some of your questions came from, Heather. I'm not sure, but perhaps. So, is there anything else?
That was exactly where they came from.
Oh, okay. Thank you.
So George had a question about supportive housing. George, please go ahead.
My question is, supportive housing falls under the discretionary use of the CPC, which I understand supportive housing is 6 residents or more. Group housing, which is 5 residents or less, is not considered supportive housing. I guess it's considered group housing. And is that a discretionary use that is under the development officer somewhere, or is it an acceptable usage?
So the way that the current bylaw, like the current draft bylaw is written, and we do have a slide also for supportive housing where we will take some time to chat about that. So the way it's proposed in the draft bylaw, because we currently do have some supportive housing or some group housing occurring in Cochrane that's been in existence for a number of years, and they've yielded no complaints so far. So when we were putting together the regulations for this bylaw, we wanted to be cognizant of, we already have these uses in the community, and they can potentially be uses that might need to be discrete, depending on the type of group housing that it is. Through planning and legislation, we are not allowed to regulate users. We can regulate use, but we can't regulate users. So we can't say it's okay for a certain type of people to live in here and we consider it a dwelling unit, but those other people can't live there because they're a different type of user. So that's something that we're not allowed to do. We have received quite a bit of feedback, which we're currently putting together all of our comments that we have received during this engagement process. We have now received feedback about supportive housing, and we will be taking a look at how we're proposing it. But the way that it's proposed, and we'll chat about this in a couple minutes from now, would be that 6 or more would be considered supportive housing under the CPC's discretionary authority, and 5 or less was that, and there is 5 or less, and you're essentially living with the occupant of the home, would be considered a dwelling unit, right? Because we wanted to be sensitive to the fact that we do have some of these uses currently in the community when we were putting together these regulations. But now that we have some feedback, we know that we do have to take another look at the proposed regulations.
Okay, I wanted to know where it fell, and now you've explained it very well. Thank you.
So, is there any other questions?
I believe, Mr. Parsons, you had, Adam, please go ahead. I think you had a comment.
Yeah, it was just a comment on the back to work and commercial. As I work downtown, we have about 5 million square feet of commercial space. So we've had a lot of discussion on people coming back to work, how many people will. A lot of our tenants are going to be having their people do shared work hours, you know, like 3 days a week in the office, 2 days a week at home. So that's definitely going to be impacting, I guess, our neighborhoods in the future, because it doesn't look like it's going to change anytime. And they're going to redevelop their office spaces. So, you know, the days of cubicles will be gone. It'll be much larger spaces between desks, things like that. You know, the same size floor plate with maybe half the people on the floor. So just thought I'd make that comment.
Awesome, thank you. No, that's definitely a great comment to hear. And that's kind of what we were thinking in terms of, you know, maybe allowing for that opportunity for an employee out of a home occupation class too.
It's especially like the smaller tenants where they can just have their employees work from home and not have to worry about paying for an office, even though we're practically giving away space right now.
Absolutely. No, that's a great point for sure. All right, so some of the changes, so as Heather alluded to during our last slide, there are some changes being proposed to development permits not required. This section, we currently have this section within the land use bylaw. And some of the notable changes to the existing regulations is that now development permits will be required for an accessory building with a party wall. And so this change was very key, and it plays into the parking, the perceived parking issues within the residential areas, and some of the problems that we have seen related to banks of garages that are located at the rear of a street-oriented townhome. So currently you do not need a development permit if you are building a garage that is 52.5 square meters or less. In many situations, the garages that span property lines with party walls right on the property lines. And the way that that clause is written is that many of those don't require development permits, just based on that exemption under this section. And in some cases, there are also, this is also, if you have an accessory building that's associated with a street-oriented townhome, you'll be required to get a development permit for it. We have had some instances where some of the townhouses are constructed at a minimum, at the minimum lot width of 5.5 for a townhome. And then when someone comes in and builds a garage, they're required to leave 2 feet on either side from the property line. So if it doesn't have a party wall, then automatically they are set in that additional 4 feet. And if their lot is at the narrowest, then they aren't meeting the parking stall requirements by constructing that garage. So we wanted to ensure that there was consideration and a review on these development permit applications to ensure that the parking stall requirements were still being maintained for these types of developments. One of the other notable changes that we are proposing is that while this is currently within the bylaw, the wording around it has caused a lot of confusion. So we've clarified the wording on the change of use of a building. So if, let's say, one of the properties in the quarry, if one of the businesses within the quarry strip mall development were to move out and there was to be another retail store or a business that wanted to move in, if that business was considered a permitted use within that district, then they could move in. But first we would require them to just fill out the paperwork so that the review is being conducted, that we can ensure that they are a permitted use. And if they aren't a permitted use, if they're discretionary, they need a development permit. One of the other changes that we are proposing is that under the current bylaw, a cannabis retail store is defined separately from other retail stores. So what we're proposing is to consider it to be a retail service, like liquor stores are currently considered, and to allow the provincial regulations to prevail kind of. So provincially, there are regulations that require setbacks from schools, from, I'm just trying to recall all of the uses, from schools, from healthcare, provincial healthcare facilities. There's also regulations restricting the type of advertising, and that's also similar to liquor stores as well. So what we're proposing is to consider that a retail service, and if it's permitted use, they would be allowed to fill out our change of use form and move in without a development permit. They would still be required to follow the provincial regulations with setbacks. The next notable change is currently we do not require development permits for swimming pools and hot tubs. Up to 75 square meters. So if you're building a swimming pool that's 75 square meters in area, that's going to be a pretty significant swimming pool. One of the reasons for this change was that we're only going to allow above ground. So if it's one of those more temporary structures, then you wouldn't need a development permit. But if it's in ground, you would be required to get a development permit. And that's because the terrain in Cochrane, if you're building or if you're digging a hole that's 75 square meters in area, the integrity of the bank and the slope could significantly be compromised, which could result in a number of issues related to bank slumping, slopes falling. So we just wanted to ensure that there was going to be some consideration and review completed for these types of developments. Some of the other considerations for this section.
Jill, sorry, I'm just going to interrupt for a second. George does have a comment, and so does Deb has a question as well. So George, please go ahead.
Jill, so my understanding is that the development permit is required for accessory building with a party wall, which I think is a great thing for the community. But does this mean? But we're also saying that developers can still put a bank of garages on the laneway without having access to those middle backyards. Is this correct? Since they do not, developers do not require development permits, my understanding.
So, sorry, and just to provide a little bit of clarification on that, I kind of stumbled on my words there a little bit, got a little excited over it. So essentially what we are proposing is that if you have I'm just thinking back to the exact wording. So an accessory building up to 52.5 square meters in area that's associated with a single detached dwelling or a semi-detached dwelling, but does not include a party wall, does not require a permit. So I'm just looking across the back alley right now from me, and I back onto a bank of townhouses. So currently, the garages that are detached don't require a development permit. That includes a whole bank of them, right? So now by clarifying and changing that rule, those banks of garages will now require a DP. And so there is a number of reasons for that change. One of the most significant reasons for that change is related to drainage. But of course, there's issues with rear yard access as well.
I guess I was trying to understand whether this applies to a new development, where a developer in Greystone, let's say, for example, has to abide by some of these regulations, or is this just applied outside of a new development to existing developments, the existing areas? Sorry.
So this, as soon as it's adopted, this would apply to all properties. So if it's something that was built prior to this bylaw being adopted, then it would be, and if it didn't meet the regulations, then it would be considered legal non-conforming. But as soon as it's adopted, essentially all of the properties, if they're going to develop after, they would need to get a development permit for that type of development. They could go for it at the same time as they're getting the development permit for their townhomes, though. So.
Okay. Thank you.
Okay, and Deb, please go ahead. You had a couple of questions there you would like to ask.
The first question, Jill, was looking at the change of use to a permitted use, or use of a building to a permitted use. Is there a check, I guess, with respect to the parking that's going to be now required with the change of use? So you have a building type, and you've determined that X number of parking stalls will need to be provided in accordance with that use, and now it's changing use. What is the check and balance that the new use may require additional parking?
That's a great question. We actually will be going through our parking strategy, which in a little bit here, which will hopefully help alleviate some of those concerns. But what we are proposing, though, related to change of use, is that there are no parking requirements for a change of use. And this is very strategic to ensure that we don't have these vacant buildings located throughout the community that no one can meet the parking requirement, and there's nowhere to get parking from because the area is completely built out. It's kind of a little unreasonable to try to require someone in the historic downtown to meet a parking regulation when there's no place for parking. And so what we are proposing through the new land use bylaw is that a change of use would have no parking regulation associated with it.
Okay. A second question, and I'm sure it doesn't happen very often, but I have seen it in Cochrane. When people have a garage, and I don't even know what it's called, but it's an elevator where they can have more than one vehicle in it. I saw one that was in the ground, and then it had a lift. Maybe it's called a lift, where a second vehicle could be stored in that. Is that something that needs a development permit or not?
And It would depend on the height of the garage, right? So we currently have a height regulation. It's 5.4 meters for an accessory building. And if they're able to put a car lift within their garage, then we really don't have any restrictions regarding that. As soon as they want to build a taller garage than what our bylaw allows for, then you of course have to get a variance, or essentially that would be a variance to our land use bylaw, and you would need to get a DP for it.
Okay, thank you. Yeah, the example I saw, they actually dug in the ground somehow and then put the vehicle down and then on top. So I was just wondering whether or not there was a development permit required for that.
I think an important clarification, Deb, is that they would still be required to get a building permit. So even though it doesn't require, it may not require a development permit, they would still be required to get a building permit for the structure, for the lift, and also for the garage itself.
Okay, thank you. Do we have
So
any other questions, Riley? I think we've
no,
covered
that's all the questions. Yeah, please. Yeah, Jill, I think you're okay to proceed. Yeah, thank you. Yeah.
All right. So some of the new considerations added to this section, they've kind of some of these have kind of already been treated this way. We just wanted to provide this clarification to ensure that there was no issues with the way that the bylaw was being, of course, reviewed, and depending on who the planner was, that everyone essentially had the same information. So new considerations have been added, which include a community garden. And so this is to help encourage urban agriculture within our community. Very specific, related to these gardens being not for profit. The next one is the development of a park. These currently don't get development permits, but we just wanted to ensure that this was included within this section. Markets, special function tents, or outdoor amusement parks. So we do have a permit, not a development permit process for this, but we do have a special events permit for these types of uses. They're temporary, and we just wanted to ensure that this was covered off within this section. A temporary commercial service, which these would allow for things like our fruit stands, the windshield chip repair tents that we see in the parking lots during the summer. The next one was a temporary shipping and storage container. So this is temporary. It's only allowed for 60 days, and it's only if it's in relation to a construction project. We just, again, wanted to clean things up, make sure that these were noted in the bylaw. The next thing is uses and developments exempted under the MGA. So examples of that would be like a public roadway and that sort of thing. Utilities on public land and utilities on private land. And then one of the additional things that we've included in here is any other development at the discretion of the planning manager. So it's really difficult to anticipate what type of development or what might come up. So this was key in including it within this section. Things that might want to be considered under this would be our current bylaw talks about, you know, it's a little confusing when someone is wanting to lift their house and put like a door to their basement. If there's foundation repairs, that sort of thing, you can never fully anticipate something that might not need a development permit. It doesn't have any gross floor area increases. It really wouldn't impact anyone. It's just a small change. So we did include that within this section. All right. All right, so the next section that we did want to talk about from the admin part is decisions on development applications. So a permitted use with no variance, the development authority shall issue the DP. Advertising in the newspaper is no longer required by the land use bylaw. This is a shift many new land use bylaws are making. Riley had talked about this previously. A permitted use is a use that you're allowed as of right. There is no appeal to a permitted use. The only appeal is if someone is appealing saying that the development authority did not approve an application correctly. So there's no approve on the use. These are allowed as of right. So if we kind of think about something within our residential area, if I wanted to build a deck, so long as I meet the regulations for a deck, I'm allowed to build it as of right. It's a permitted use. I can build it on my property. There is no appeal from the neighbors allowed. If it's now for a discretionary use or a permitted use with a variance, the development authority shall provide the decision to the applicant. So we're not issuing the DP, we're providing them with their notice of decision. And then we're advertising the development permit, which the advertising bylaw was just updated. And then we're required to notify adjacent landowners. So there are two ways that these applications are required to be advertised, or we're required to notify adjacent landowners. And that's through posting a sign on the property within I just got to find that section, but this notice has to be posted prior to a decision being rendered by the development authority, and it has to stay on the site for the duration of the appeal period until after the appeal period has passed and the development permit has been issued. The next thing that we're requiring occurs in relation to notifying adjacent landowners is that a letter will be sent to each adjacent landowner indicating that this development is occurring on the property. So we just wanted to kind of circle back to this because it did come up previously during our discussion. The major change is related to permitted uses. So this is a major component to the red tape reduction goal, is that because these are permitted uses and there is no appeal to a permitted use, this process is a little bit more streamlined. The discretionary uses, because these are usually more contentious and can be controversial in a community, or a permitted use that includes a variance, there is much more of an extensive process for these types of applications, and that's a major change from the current bylaw. Another change to this section is the commencement and completion of a development permits. So development permits will not come into effect until 21 days after a public notice is issued and after all prior to release conditions have been satisfied. So that's accounting for that appeal period. Now, one of the things that we are proposing through this bylaw is to have a voluntary waiver of claims, which can be issued if you have a permitted use with no variance. It would just essentially say, we're releasing your development permit to you prior to this appeal period being complete because there is no variance to it and it's permitted, so it's generally low risk. You can proceed with construction. However, if there is an appeal, you have to halt all development on site. And if the appeal is upheld, you have to convert the property back to its previous state at your expense. So this is one way of helping streamline the development permitting process. This is something that is used in another community that I'm familiar with, and it was very effective in helping these permitted low risk developments get moving quicker. Does anyone have any questions?
Yes, Jill, there is one question from Heather. Please go ahead, Heather.
Sorry if I'm kind of beating a dead horse here, but the 21 days is required when there's a development permit for a discretionary use or a permitted use with a variance. In that situation, in one of those two situations, there cannot be a voluntary waiver of claims. Is that correct?
That's correct.
And I'm confused because for permitted use, you don't need a development permit. Is that correct?
That's not correct.
Okay,
Sorry. I'm sorry about that.
No, it's okay.
No. So permitted uses, only if they're listed in that section that we went through previously that say development permits not required.
Okay.
Only then are they not. Only then are they exempt from getting a development permit. A permitted use, if it's not listed there, then you still need a development permit. So if you were going to build, if you were, say, located in a commercial district, you wanted to build a retail store, and it was a permitted use and it was a brand new building, you would need to get a development permit for it.
Okay.
Sorry, I don't know if that helps at all.
It does help. So like was a home business is that a permitted use or discretionary?
No, that's a great question. So a home occupation class 2 is a discretionary use in all of our residential districts, in some of our commercial districts, because they are commercial. And if it's, say, like an apartment building, we have allowed them as a permitted use, but they aren't exempt from getting a development permit in those areas. So they'd still need to get one.
So is there a section that, well, I guess if it's not on that list, then you have to have a permit, even if it's a permitted use.
And that's why it was really important for us to go through, and some of those things that I noted on the previous slide, I know they probably seemed kind of like, oh, why are we covering these off? But things like utilities, I mean, how do you run power to your house, right? Or water to the house? They're technically not currently exempt under that section, but it's just something that should go along with the house, right? So we just wanted to ensure that they were captured in that section.
If I can, Jill, I think, Heather, it's a really good question. Like, I think the best way to think of it is starting with everything needs a permit, and then looking at the list at the beginning, like regardless if it's a permitted use or a discretionary use, everything needs a permit. And then those uses that are listed to exempt them from a permit, only those are the ones that are exempt and don't need it. Yeah, so regardless if it's a permitted use or not.
Sorry, Heather, you're muted.
Sorry. And the 21 days, the 21 days can only have a waiver of claims if it is a permitted use.
Yes, and that's the only time we'll allow for it, and it's still at our discretion. So if it's, you know, that example I provided earlier about if it's in a commercial district and you're building a brand new retail store, we're probably not going to issue a voluntary waiver of claims, because we're probably going to say, you know, that's a multi-million-dollar development. You can wait out the 21 days so you
Right.
can
So not tear anything down later, right?
Exactly.
So just for my own clarification, if the applicant goes ahead and then it comes to that they should not have started, then they will be required to change the property back to where it was and will hold all of the costs related to that. Yes. And will he also be fined?
And that's a great question. So it just depends if they've received the development permit and they've been issued. So they don't automatically have the opportunity to sign that voluntary waiver of claims. It's at the discretion of the development authority. We might not allow the permitted use to do it. And as I was alluding to earlier, if you don't get a development permit and don't have that voluntary waiver of claims issued back to you saying, here you go, you don't have an active, valid development permit, so you'd be fined for not having a DP and beginning work. If you start, but you've gone through the process and signed the waiver of claims and been issued your DP, then you can begin. I mean, you'd probably just want to start your groundwork or surveying, kind of low cost things.
Mm-hmm. Okay, thank you.
Okay, Jill, we don't have any other questions. So I think we're good to proceed.
All right. So one of the new sections to the proposed bylaw is that we have a section just in an attempt to clean up our districts a little bit, because we have a lot of uses that were listed in every single district. We just created this one section that says uses permitted and discretionary in all districts. So permitted in all districts are community gardens. This is what we currently have listed in this section. So community gardens, protective services. So those are our ambulance, our CMP buildings, fire halls, parks, public utilities, solar collectors / renewable energy systems. And that is very limited to things that don't require a DP. Under the things that don't require a DP section, you technically can only have a roof mounted solar panel without a DP. If it's on the ground or anywhere else, you need to get a development permit for that. Sales / lot information centers and show homes in the residential areas only. And then day homes in residential areas only as well, which is a current section or a current change to our bylaw that was made fairly recently. So we also within the section have a clause that says this use is discretionary in all districts, and that's excavation, stripping, and grading. So that's if, say, a developer wants to get going on a subdivision, it's discretionary. And because we want to ensure that they're doing it safely and they're doing proper ground control, but we wanted to list it as a use there so it's clear. All right, so one of the things that this new bylaw is proposing is to create overlay districts, or to bring overlay districts into the new bylaw. So what we currently have is we have districts that are indicated on our land use maps. So this would be an additional map that overlays on top of the zoning of the property. So we are proposing 2 overlays to be established under this bylaw, and that would be for the Western Heritage Design Framework overlay, and then the digital sign overlay, which we currently have. However, it's not really integrated into our bylaw. This is just saying where digital signs may be considered as a discretionary use in Cochrane. This map, we just kind of wanted to show what it would look like. This map, do not take it for, take it as just kind of an example of what we mean by an overlay district. So an overlay is in addition to and not in substitution for other development regulations. So whichever regulation is more strict, then it defaults to the stricter regulation. All right. So it looks like Riley, do we want to take a break?
Yeah, Jill, I think maybe, is there, how many more slides are left in the administrative section?
There's just 2 slides left, and they're pretty quick, actually, the direct control and enforcement. So.
Jill, can I just ask a question with respect to digital signs?
Yep.
Along the way, we've discussed the dark sky philosophy or guidance. Has that been discussed or referred to within the land use bylaw, or is that more of discussion when the MDP is updated?
And that's a really great point that you brought up. So we are still maintaining the backlit sign regulations that we currently have. So you'd still have to go to CPC for a backlit sign. We do have regulations that are specific within our lighting section that essentially says that lights have to be directed downwards. You cannot pollute other sites with your lighting, and you also cannot pollute roadways with your lighting. The only lights that are allowed to do that are town infrastructure lights. And that's for a number of reasons. The main one, of course, is for vehicular movement. And just depending on like the LED brightness that could bleed onto a road from a site.
Okay, thank you. And I believe Heather has a question. Do you, Heather?
Yeah, just real quick. So the overlay maps, I know that that's just an example, but will those be finalized and set more concrete in the actual final proposed use bylaw?
Yes, so the Western Heritage Design Framework overlay, so there was I believe CPC engaged. Riley, you might have to help me out with that. Was CPC engaged on the Western Heritage Design Framework?
Yep.
Yeah.
Sorry.
So the way that that would integrate into this bylaw is that it would be a schedule to this bylaw saying you have to abide by this and then refer to the maps within that overlay. So while there's overlays, of course, there's that historic town overlay, which will mostly be within our historic downtown area for our new bylaw. Those regulations are in addition to the regulations that we're proposing for that district of the land use bylaw. And then the digital sign overlay, we are having the mapping completed for it, but it's the current areas of the current bylaw where it allows for signage. We are trying to get the mapping because that mapping is quite outdated. We're just trying to get it up to date so that it looks better and it kind of matches with our theme for the proposed bylaw. And anywhere within that digital sign overlay, where it allows for signage, it still is going to be carried over to say, like, in these areas, digital signs may be considered as discretionary use.
Okay, and so just for my clarification and Jill, as they are discretionary use, so when there is an overlay such as the Western Heritage Design Framework or the digital sign, then as those are discretionary, they will come to CPC for input?
So it depends on the type of development, but the digital signs will still require CPC's input. The Western Heritage Design Framework, it depends on where that development falls on that list or within that district. So if it's within the historic town, if it's a retail service, then it could still be considered by the development officer. It just has to abide by all the regulations from the Western Heritage Design Framework overlay.
Okay. All right. I think we can discuss that one further.
All right. So I will go through direct control now. So direct control was something that was newly brought into the land use bylaw. We did see an application for direct control. Some of you guys on Planning Commission might recall back to when there was that application for zero lot line development. It was essentially being proposed as a direct control district in those areas. It was defeated by council. So we currently do not have any direct control land in Cochrane. So after we received that application, we did realize that maybe there were some efficiencies that we could make to that section to kind of make it more clear. So now we are going to have new application requirements. So we may require them to do some public engagement related to their development, but also we're not going to require them to submit their proposed regulations. Rather, we want to be establishing the regulations for their uses. And that's being done for a variety of reasons. But after we went through that process, we realized, like, why is somebody telling us how we're going to regulate that use? Rather, we should be establishing those rules to make it an acceptable use within our community. The other thing that is changing to this section is that the following uses must only be listed as a use on a parcel that has been designated direct control. So we're saying if you want to do any of these uses within this list here, you have to go through the public process, rezone the land to direct control, and we'll establish the regulations. It's going to go to council. It's going to come to CPC. It's going to have a public hearing, get 3 readings. And we have reviewed the uses that are going to be listed within this section, and we've listed them here. So we have adult entertainment, natural resource extraction / processing. So we do currently have this occurring in Cochrane. However, for new redesignations, you have to rezone to a direct control district just to ensure that there is proper considerations for regulations for that use. A mobile / manufactured home community, a solar farm, and a wind farm. And so these have and can yield some controversy in a community. So we've just gone ahead, we've defined them, and we've listed them here so that there's no way that these could be interpreted as any other use in any other district. Does anyone have any questions?
Yeah, Deb has a comment. Please go ahead, Deb.
I was just wondering if my memory serves me right. I believe that we had a direct control district in the proposed land north of Heritage Hills, where at one point, and then it was redesignated. There's a change back or to a different designation. Is that correct? Was there one there?
There was an application for a direct control district. You are correct, for a portion of the lands directly north of the Heritage Hills community that were recently annexed into the town. That land is now all public service land. There was a potential for the Southland buses to be located at the northwest corner, and it was suggested or actually proposed for that portion of that land to be a direct control district to regulate the bus use. But that was ultimately removed from the application, and therefore all of the land was designated as public service instead. So yeah, there is no direct control district.
Okay, thanks. I was just checking my memory. Just a suggestion, I'm wondering if you might want to add those mobile towers, those mobile transmission towers, as something that needs to be looked at in direct control areas. We've had quite some conversation about some of those in the past in my tenure on CPC.
Are referring to the telecommunication towers,
Mm-hmm.
the mobile phone, and that's a really great point. So those are actually federally regulated. So the town of Cochrane does have a process for those. They do get reviewed by council, and then a letter is submitted to the cell phone company and to essentially to the phone company as part of their circulation. And essentially it's within the federal jurisdiction whether they're approved or not. So we really have limited ability to regulate them because they fall under the federal government.
Yeah, yes, I think, did we not have some right or input into the finishing of those? Not so much about where they were located there, but what they were going to look like. So the materials on the outside, what it's going to look like to the environment and to our view as residents.
Yes, we do, Deb. So the town does have guidelines that were established a number of years ago for mobile towers, and part of the guidelines do include location criteria, but also how the towers, the finishing, like you say, how they look, and the color, etc. And so again, those are guidelines, and for the most part, the telecommunication companies are actually fairly understanding of those, and have been in the past. But what I can do is I can share those guidelines with CPC if you wish to take a look at them. Yeah, and like as Jill said, It's not something that we can regulate through a direct control district or a development permit for that matter. But this has been discussed previously. We have established guidelines and a process, and yeah, we can share that with CPC.
Okay, that would be great. Thank you, Mr. Weldon.
You bet.
I see that Heather has a comment or question.
Just a comment. Do you think, given that this land use bylaw could be around for many, many more years than some of us may be still part of the planning commission or administration, for the longevity of it, do you think it would be wise to put some kind of broad, I don't want to say just broad category of things that could in the future be considered for direct control? Like, these are pretty specific. Just thinking 10 or 15 years from now, that there could be something that we didn't think about. You know, our lives are changing every day now with COVID. So that there might be an addition of like just a broad category. I don't know how to word that. That's what you guys are there for, but to give administration or the council the opportunity to weigh in on the more controversial type things.
That's interesting you say that, Heather. One of the things that comes to mind immediately is there's going to be different kinds of power plants and things like that. And we don't know yet because of innovation is around the corner. And so there may be some kind of broad comment about things to come or whatever, as you say, the wording is appropriate. Just a suggestion.
Yeah, that's something we'll definitely take a look at.
Yeah, it's a good suggestion. Thank you, Heather. So Jill, I think I don't see any other questions or comments. I think we're good to get to the last slide, I think, on enforcement. And then I suggest we take a break after that. Yeah.
All right, so as Riley had mentioned, so this is the last slide within the admin section. So Bob, our bylaw officer, has reached out to us, and he's been in conversation with the Crown prosecutor, and our current enforcement section is extremely hard to enforce. A lot of it kind of just defaults to certain sections of the bylaw, and the Crown prosecutor has suggested changes. Of course, we've had legal review done on the bylaw, and the Crown prosecutor is also reviewing this section of the bylaw. But essentially what we're saying within the enforcement section is that where a peace officer believes that a person has contravened any provision of this bylaw, they may commence proceedings by issuing a violation ticket. The minimum penalties for offenses shall be specified in the Town of Cochrane Planning Services fee schedule. So that was important to put it in the fee schedule as opposed to putting it within the bylaw. Now, once we get our final review from legal, we might end up having to put it in the bylaw, but we wanted to ensure it was easy to change. So if we had to increase or add a fee, it wouldn't have to go through 3 readings, that it could be approved by council in a schedule form. And then some important highlights is that when a person or business is in contravention of the same provision twice in 12 months, the minimum penalty shall be twice the amount in the fee schedule. And then if the contravention occurs 3 times, the penalty shall be 3 times the amount. So currently we have no guidance on that, but what we're essentially saying is you break that section, or you are in violation of that section of the bylaw once, you get the minimum, or you get the 1 fine amount. And then the second time it's double that fee. and third and any subsequent times following that, it's triple the fine amount within the 12-month period. And believe me, people think that it's cheaper to pay the fine than to wait for their development permit. So at least we have that tier system where you're not just being fined $100 and well, that's cheap enough. It's going to increase every time you do it. And that is,
Jill, I have a comment on the fee structure. If you could go back to that slide. I'm just wondering, and I know that you have experience with other municipalities, about what the actual fines are, because some people are indeed willing just to pay an amount because it seems seemingly a small amount. But in the case where it's a blatant gone ahead and build a garage that's a meter higher than it should be, for example, has there been some thought, because they're not going to do it 2 or 3 times, has there been some thought as to the severity of the contravention and the related fee?
absolutely. So the fees that we have and are currently being reviewed are significantly higher than they are currently. So of course, our current bylaw says that we can issue like a ticket up to $10,000. So it's really discretionary, and obviously we don't use that high end $10,000 mark, but it depends on which section or what type of violation it is. If it's starting work without a development permit, of course, it's more significant than, say, you put a portable sign that can really easily be moved on a site. It's a little bit less, right? So, or it's quite a bit less. So it varies, and that'll form part of our final bylaw engagement, or with our final section of the land use bylaw. We plan on including all of the planning services fee schedule within there.
Well, thank you. And I'm glad to see that there's some ability and some flexibility to actually levy a higher fee, because human behavior, being what human behavior is if you do it once and it becomes folklore, so to speak, and is well talked about across the community, it might inhibit or stop people from doing the same thing. So it's good that it's at least in there, so you have that flexibility.
Awesome. Yeah, absolutely. And that was really important for this bylaw. Of course, you want it to be a deterrent. In my previous life, I've seen multi-million-dollar projects not wanting to pay for freeze rates. So going ahead and pouring foundations and then paying $1,000 fee because it's cheaper than paying a freeze pour, than waiting, so, and they'll pay it for days until their development permit is approved. So so I realized we just had this last slide in the admin section. It was hiding there, but if we have another 2 minutes, I can cover this one off fairly quickly. So this is just the section of the bylaw that talks about effective date and transition. This is one thing that I just thought that you guys might be interested in when it takes effect. So of course, as soon as the bylaw is adopted, the new bylaw is the law of the day. So all developments will be required to follow that bylaw. Any application received prior to the bylaw, but that hasn't been reviewed or hasn't had a decision rendered on it, the applicant can issue us a written request to have it considered under the new bylaw. So we'll hold off on issuing a decision and we'll wait for the new bylaw to be approved. And then anything received after, again, shall be considered under the new bylaw. And that's all of our admin section. And if, sorry about that.
So Jill, if you go back to the previous slide. So just to make sure that everybody's on the same page. So when the bylaw is redrafted and ready to go to council, it'll go to council for first reading. We'll then go to public engagement and then go back to council for second reading and third reading. Do I have that right?
Yes, yeah, it'll go for second and third reading, and then once it receives third reading, it becomes an official bylaw.
Okay, thank you. Just wanted to make sure that everybody was on the same page and had the same understanding. So it is 8:03. Would we like to take a 5-minute or 7-minute, come back at 8:10? Is everybody would like to have a break? I have a couple thumbs up. So should we go with 8:10? A 7-minute? Somewhere between 5 and 10, we'll go with 7. How does that sound? Good? Okay.
Sounds good. And I'll just remind everybody, we will still be live streaming. So I suggest everybody turn off your cameras and mute your microphone. And then please, when you come back, please just turn your camera back on so that we know that you're back. Okay, thank you.
Okay, I think it is 8:12, and I think mostly everybody is back. Are you back, Adam? Yes. So I think, Jill, whenever you're ready, I think we may proceed.
Awesome. Thank you guys. So now I'm going to give you guys a little bit of a break from listening to my voice, and I'm going to let Joelle talk to you guys about districts and some of our general regulations that we are proposing through the draft bylaw.
Hi, everyone. So as Jill mentioned, we won't be going through our districts one by one as we have already covered them in detail in previous engagement with this group. But given that we do have some new members, we wanted to provide an overview of how all districts will be transitioning in the new bylaw. So we have reduced the total number of districts in the bylaw. And we've created more consistency in the application of districts across property types, which we'll take a look at now. So starting with residential districts, we've reduced the total number of districts from 7 to 5. However, we do have one brand new district, which is the Residential Large Lot District, or RLL. So this will not be applied to any existing properties, however, can be applied to new residential areas. And as the name suggests, it is meant for single detached housing on wider and larger lots than in our standard single detached district. So if you take a look at this chart here, all R1 properties, which is our single detached district, will transition to RLD, which is our new residential low density district. All properties currently zoned R2, R2X, and RCL will transition to RMX, which is our new residential mixed district, which will accommodate a mix of housing types. Most R3 properties will transition to RMD, which is our medium density district, and RM properties will transition to RHD, which is the residential high density district. Does anyone have any questions about residential?
Was there guidelines? I didn't see them, so I may have just missed them with respect to the large lot as far as is that to be determined or just in the future, or have they already been determined in lot size?
So all of the minimum lot widths and lot areas are prescribed within that district. And that is available in the draft that's posted. Is that what you're asking?
Yes, I was just wondering what the minimum was because I missed that.
Sure. So let me just bring it up here. The minimum lot width in RLL is 14 meters, I believe. And the minimum lot area is 420 meters squared.
Okay, thank you.
No worries. Does anyone else have any questions?
Yes, George has a question. Please go ahead, George.
Yeah, yes, it more has to do whether this question belongs to the LUB or somewhere else, but I am concerned about infills. Excuse me. I'm concerned about infills and redevelopment of communities or revitalization of communities when it comes to affordability. I have seen in areas of Calgary, such as Martin, for example, where an aged community, an aged area, an aged district gets these infills, which prices out people who live there, basically. A person who wants to live in place, or age in place, sells their home and finds out that other home that they want to go into are no longer affordable because of how much that revitalization or gentrification has happened in a neighborhood. And like I said, my question is this really applicable in the land bylaw, or is it more somewhere else addressed, such as the municipal development plan, that kind of a concern?
And that's a really great question, George. And I know that some of the residents within some of our more mature communities in Cochrane would like to see their area develop. Well, based on some of the conversations that we've had with their community association, would like to see their areas redevelop. Generally, the process for that is that if there is a specific neighborhood that is maturing, then you would have a area redevelopment plan that covers that area and talks specifically about the development and how the development should occur, how redevelopment should occur within that area. Of course, when it's in an aging community, and I can talk about this fairly because I do have quite a bit of experience. I've written neighborhood plans and area redevelopment plans in other communities. And these areas, generally, it's when you start to see development is when it becomes a priority of council. So of course, we're a fairly blossoming and developing community here. And we have just started working on updating some of our policies. So while I could see this being, these area redevelopment plans being an upcoming project for the planning team, of course, we have a number of documents that need to be updated. One of the things we did do with this bylaw was we tried to be mindful of the development of those areas, and that maybe there might start to be some purchasers interested in purchasing those larger lots and doing developments and redevelopments within those portions of town. So we have created some a section that talks about infill development, and we've prescribed some regulations in hopes that it will help minimize the impacts if we do start to see this, and in lieu of an area redevelopment happening. So some of these regulations within the proposed bylaw are related to the front yard setback. So of course, our R1 district allows a 4-meter setback, but because some of these areas are, these lots are so large, many of the properties on a street have a consistent front yard setback that's maybe 7 to 10 meters. So we're requiring for infill lots that a front yard setback be within 1 meter of either side where those are developed at. Also related to how the site is accessed. If the majority of the houses on the street don't have front access, then that one won't be allowed to have front access. And then we also have a regulation that requires that street trees be maintained. So we will not approve a development that would require the removal of a mature tree in the boulevard. So we're just trying to kind of help allow for this development to occur, but trying to be mindful of the impacts that it could have, that they could have on existing.
I wasn't against redevelopment. I'm glad to hear that it's on administration's radar, and that I was concerned it could be, if it wasn't on your radar, it could be a free-for-all out there, but I'm glad to hear that you're on top of it. Thank you.
For sure.
Okay, Joelle, there are no other questions that I see. So yeah, you can please proceed.
Perfect. So moving on to commercial districts, as you can see, there has also been a significant decrease to our total number of commercial districts. As we spoke about, we really made an effort to clarify purpose statements to reduce inconsistencies and ensure that appropriate development types are located in each of our new districts. So as you can see, the transition for commercial districts wasn't quite as streamlined as residential, as we did have to look at the uses that existed on every property to ensure that they were appropriately zoned. But looking at this chart, some of the CR and CB parcels along Center Ave and along First Street, as well as the property at 305 Ross Ave, will be transitioning to CT, which is our commercial transition district. So this is a new district that is meant to act as a transition between commercial and residential areas, such as the area between the historic downtown and the East End. And it accommodates low intensity commercial uses, as well as residential mixed use developments. Commercial properties currently located in our historic downtown will be zoned another new district, which Jill mentioned, which is the commercial historic downtown district, which has been crafted to accommodate a range of lower intensity commercial uses with an emphasis on pedestrian oriented design in that area. Local commercial, as well as some commercial residential mixed use and shopping center parcels, which are C, CR, and CSE, will transition to the neighborhood commercial district, which is meant for commercial areas within communities. Remaining central business, service, commercial, and shopping center parcels will be zoned general commercial, which has the largest variety of commercial uses. And all highway commercial parcels will transition to the new highway commercial district, which is meant for larger scale and more car-oriented uses.
Okay. And Joelle, George has a question.
Okay.
Joel, I think I saw in the presentation to council that you made that in the commercial historic, it's allowed up to 6 stories high a building. Am I correct?
That is, sorry, I'm just going to scroll through so I don't give you false information.
And if it is correct, obviously my concern is 6 stories. And wouldn't a mixed use 4-story be sufficient for a historic area? As a comment from CPC.
Right. Jill, do you want to speak to that at all?
Sure, absolutely. And that's a great question. So currently we don't have any guidelines regarding heights within our guiding policy documents. So nothing within our municipal development plan. Within our current land use bylaw, we are allowed to approve development. Well, the Cochrane Planning Commission is up to 6 stories under our current bylaw. The reason for the change, or the reason for allowing up to 6 stories, was in relation to council's vision. So they really indicated within their vision that they put forward that they would like to see the more dense development occur at the center of town. So that would, of course, be within the historic downtown area. So we wanted to ensure that the height requirement would accommodate more of a dense development. So you'll also see that in other commercial areas. Of course, that area, which is the historic area, I believe has the most requirements or most guidelines under the Western Heritage Design Framework. So there are other elements that we are proposing that would help minimize the impacts on the pedestrian, which Joelle will speak to if you do have a tall building. So if you go above 3 stories, you do have to step it back. But it was related to council's vision and where they see the more dense development occurring in town.
Well, I guess my opinion is counter to council's opinion. I think that 6 stories in a historic area is an overkill, but that's just my opinion. Thank you.
So Joelle, for my own clarification again, I think I read somewhere that the maximum was for height of a building was 25 meters. Is that correct?
In this district?
In any district in Cochrane?
So each district has its own maximum height requirement. So the residential districts are indicated in meters, and then all of our non-residential are indicated in stories. So I believe the max in our high density residential district is 25 meters, but then all of the commercial and industrial districts have their own height requirements and stories. And George was correct, it is 6 stories in this district.
Okay, so when I read that, so I understood that it was, the way I read it, that it was 25 meters across Cochrane. So I, like George, am concerned about that height in historic downtown. I understand council's vision and the need to have more of the population centrally located. I don't know that I agree with that being right within the historic downtown and within the geography of that as it's defined.
Right. We can definitely make note of that.
And I do believe that Heather has a comment.
Yeah, so, and correct me if I'm wrong, but the historic downtown area was the area that we were talking about earlier when we were talking about parking, in that we weren't going to put restrictions on new businesses moving in if there wasn't enough parking, because there really isn't a way to add more parking. Am I correct in thinking that?
Yep, that's correct. So
Okay.
there won't be a parking requirement for.
Right, so that 6-story building will be put in a place where there's no parking requirement. Is there anything specific to that building where if it's 6 stories or above 3 stories or something like that, they would have to include like underground parking? Or because that's a lot of, in that 6-story building, there can be a lot of traffic.
And Joelle, maybe I can help with this question. And that's a really great question. We do have a section all about the parking strategy where we talk about, it's not that there is no consideration for parking, it's just that when there's a change of use. So there's, if we take a look at McKay's, and if McKay's were ever to move, which we hope that would never ever happen. I personally hope that. So if they were to move from their location and we were to say have a retail store that wanted to move in there, that change of use would not have a parking requirement. But we have a separate parking strategy that we're going to talk about in a couple slides, and we have some slides that I think will help explain a little bit better than I can.
We can put that on hold.
Okay.
All coming.
Yeah, I don't see any comments or questions, Joelle. So yeah, I think you can go on to the next slide.
Perfect. So industrial districts, as you can see, had a bit of a smoother transition. So all of our business park parcels, which are MBP, will transition to the business industrial district, which is for lighter industrial and commercial uses that don't create a nuisance outside of an enclosed building. General industrial, which is M1 currently, will transition to the new general industrial district, which is meant for larger scale industrial operations, which could include outdoor storage. And parcels currently zoned gravel extraction, which is GE, will transition to special industrial, which is similarly meant for natural resource processing. And this district can only be applied to parcels which currently have the GE land use. So this cannot be applied to any new parcels. Deb, you have a comment?
I do. Well, just a question. And maybe it's not in the land use bylaw, maybe it's elsewhere, but do we have noise bylaws with respect to industries such as this that are permitted in these areas?
Yep. So the noise bylaw does cover non-residential development.
So is it included, sorry, just for my own clarification, is it in the land use bylaw then with respect to noise?
No, the specific noise bylaw is a different bylaw. So those specific specifications aren't included in the land use bylaw.
Okay.
But we have coordinated these districts so that nuisance is taken into account, if that makes sense. So where there is going to be more noise suspected, like in the general industrial district, we require larger buffers and larger setbacks between different districts. So that is accounted for, which we will touch on a bit in our landscaping section.
Okay. And another question just with respect to, and yes, we want development. I'm just wondering, how do we plan for, anticipate water use of these different industries?
Joelle, that's a good question, Deb, and it's a difficult one to answer. We would need to assess each industry as they come in and as they apply for their development permit based on their water needs, and how that impacts the overall water capacity for the town. But that's done really throughout the entire process, from our business attraction through the development permitting process and planning process, such as redesignation, and those things are considered then. But it's really on a case-by-case basis, dependent on the industry itself, and it's really difficult to really know what the water needs are going to be on from one industry or one business to the next.
So could we conceivably, Riley, get to a point where we have to turn down an industry because of our water limitations?
You know, I want to be careful how I answer this, because you know, we do have a water license that allows us to draw water at up to a certain capacity, and so you know, as long as the industry is working within that, we would analyze the impact on the overall water draw based on what the anticipated growth for Cochrane is. I think there'd just be a lot of different analysis that would be needed on that case-by-case basis. I'm hesitant to say yes, because I think it's just so circumstantial. But you know, we have a lot of capacity remaining for growth within Cochrane. I'm pretty confident that any business or industry that is interested in coming to Cochrane can be accommodated within our current water license, and we are actively looking at and exploring of getting new water licenses as well. So it's a complicated answer.
It's okay, Riley. It's quite speculative. And just that the understanding of what I've read with respect to the water license, it seems to be always tied to the number of residents. And I know that we have enough water or sufficient water in our current water licenses for our projected growth to 60,000. But I've just never really seen any tie to or contemplating what industry is also going to cost us from a water perspective.
Sure. Yeah, it's a good consideration, Deb. And I think the best way to look at water licensing is growth. And I know it's always really related to population and residential growth, and maybe less so on the non-residential side. But the water license is associated with growth in general. We do have industry in Cochrane, actually quite a bit of industry, and that's factored into the overall growth of the community. And I think that's the best way to look at it. But it's good, because you are right that it is normally associated with just the residential side, and not specifically speaks to the non-residential side.
Right. So I think there might be an opportunity, just forward thinking, that we try to, as much as possible, making sure that that businesses are recycling their own water, and you're using their water, but they're also making sure that they're using their own water over and over again, just to reduce the amount of fresh water that they're using.
Sure.
So just a comment.
Okay. No, thank you for that. Absolutely. Yeah. Okay, Joelle, I don't see any more comments. So yeah, you can move on. Thank you.
Perfect. So moving on to our last section of districts, which is our urban service districts. So urban service districts are the culmination of our current public service district and urban reserve districts. So currently we have 2 urban reserve districts, with the only major difference being that URR, or residential urban reserve, accommodates single detached dwellings, and UR does not. We have decided to combine these 2 into a single urban holdings district, which accommodates single detached dwellings. And then currently we have 1 public service district, which has quite a variety of uses and has caused some inappropriate applications of the district in the past. So to clarify this district, we have divided it into a parks and recreation district for all of our green space and parkland, and a community service district, which is meant for schools, government facilities, large churches, and larger recreation facilities like spray lakes.
Okay, one question, Joelle. So property that's within our town boundaries that is not currently being developed, but people live on it, is that an urban holding? So I'm thinking of, I believe it's a farm residence that's on the west side of Riverside, or Riviera, in that area. So what is the classification of that land, I think is my question.
I don't know, Jill, I'm not sure exactly which parcel you're speaking about. If you have the address, we can look it up on the map later to determine the exact zoning. But urban reserve or urban holdings is a holdings district. So it can have a residence on it, but it is a holdings district for potential future development.
Yeah, I can help out there, Joelle. That is the urban reserve residential area that is west of Riviera and south of the commercial area of River Heights Drive, and towards the river and adjacent to Highway 22. That is urban reserve residential. So those properties will be ultimately changed to the UH district.
Okay, thank you.
Thanks, Riley. All right, so now moving on to our general regulations and some of the highlights in these sections. So we just wanted to start out by noting that for all of our land uses, we have created broader use definitions to streamline the number of uses and provide for more flexible interpretations, as well as included new uses to account for new development types. We have also modernized regulations and included new regulations and uses that contemplate modern development trends, which include crime prevention through environmental design, pedestrian-oriented design, urban agriculture, and new parking regulations, which we will get into shortly. So crime prevention through environmental design, or CPTED, are principles for designing the built environment to create safer neighborhoods and communities. So our current bylaw doesn't speak to CPTED principles. However, in the new bylaw, we have created some flexible regulations to encourage development principles, such as providing clear sightlines between public and private spaces, providing security lighting in strategic locations, using landscaping as barriers to deter unauthorized access, using walkways, signs, landscaping, and hardscaping to identify property lines and areas of a site that are designated as off limits to the public, and maintaining landscaping and lighting, keeping sites free of garbage and graffiti, and repairing damaged and unsafe buildings and structures. So as Jill alluded to earlier, we have also included a number of measures to promote pedestrian-oriented design and make our commercial areas more pedestrian-friendly and walkable. And these are all included as special district requirements in some of our commercial districts, and include not allowing parking in the front yard or corner side yard of a site to ensure that entrances are safe and easily accessible to pedestrians, requiring any dwelling units to be located above the ground floor to ensure that streetscapes remain active, incorporating awnings and canopies into entrance design to create a protected pedestrian environment, and requiring buildings over 3 stories to incorporate a step back to create a more open streetscape.
Okay, Joelle, thank you. We have a question and then a comment.
Okay.
So my comment / question is the first line item there, not allowing park in the front yard or corner side yard of a site. There is a clause in the new bylaw that says that the development officer can make exceptions for, and if I've read this wrong, please, I know you'll correct me. The development officer or development authority can make exceptions for this based on a business's plan to design a fenced in area or a landscaped in area. Did I read that wrong, or is there an opportunity for someone to make exceptions to that?
Are you referring to this clause in particular? Or was it pertaining to?
It says, let me see here. I'm see if I can find it real quick.
I actually have the clause right here. So it states, so section A says buildings should be located at the minimum front yard and side yard setback line. Is that the one that you're referring to?
No, it's pertaining to parking, and I'm getting to it here, I think.
Heather, I do have it up in one of our districts. So the clause states parking areas shall not be located in the front yard or corner side yard of a site.
Mm-hmm. And then the next line.
Right. So do you want me to read it out for everyone?
Yeah, please do, because I can't find it.
No worries. So it says, notwithstanding subsection A, which I just read, at the discretion of the development authority, parking may be provided in the front or corner side yard of a site, provided it is screened by fencing and or landscaping to the satisfaction of the development authority. So we have built that in for a bit of flexibility, depending on how a site is oriented and how it's being proposed, just so it's not so rigid of a requirement.
I think that kind of leaves the door open for, I mean, it doesn't really follow the concept of safe entrances and being easily accessible to the pedestrian. If there's parking in front of the building, plus a fence or landscaping, I think that is a requirement that should be rigid. That's just my comment.
Sorry, Deb, was there any other?
Yes, I have a question, for my own clarification. So when we have an area such as the Western Heritage Area, is this something that is an overlay to the Western Heritage Area?
Are these regulations within the overlay? Is that what you're asking?
Mm-hmm.
Not specifically though, no. So these are directly within the land use bylaw. So Western Heritage have regulations over and above this. They do have some which kind of similarly align with the land use bylaw, but these are all within the bylaw itself, not the overlay.
Okay, so then the pedestrian-oriented design you intend to see across Cochrane or in particular areas?
So these regulations are in almost all of our commercial districts, except for the highway commercial district, just because that district is designed to be oriented for more car use than pedestrians. But it is something that we have built into all of our other commercial districts. So we hope to see those areas be more walkable in the future.
Okay, thank you. Okay, I don't think there's anybody else. So continue on.
Okay. Okay, so moving on to landscaping. So in general, we have made a lot of improvements to our landscaping section in terms of how regulations are laid out, but we did want to focus on a few sections that relate to non-residential districts. And the first of these is our xeriscaping regulations. So xeriscaping is a natural approach for constructing low maintenance, water efficient, and sustainable landscaping, which often includes but is not limited to the usage of xeric adapted plant species, gravel gardens, or rock gardens. So the current land use bylaw requires 100% xeriscaping in non-residential areas. However, that standard is quite restrictive, and we found that it's not always being met. So to provide a bit more flexibility in the new land use bylaw, we are proposing to encourage xeriscaping and reference the Town of Cochrane naturescaping standards, which outlines appropriate species to help decrease water consumption, just again to build a little bit more flexibility in and make sure that we're creating regulations that can actually be followed. We've also made some changes to our landscaping required for our business industrial district, as our current landscaping standards have proven to be a bit cumbersome in some areas, especially where there is a shortage of industrial lands available for development. So the new regulations decrease the total amount of area that needs to be landscaped, while still ensuring that landscaping is focused along public streets. We have also expanded and clarified our regulations for landscaping buffers. So landscaping buffers visibly screen and separate land use districts from one another to mitigate noise, lighting, and other nuisances. Our current buffering regulations are quite non-specific and don't provide much guidance. So they have been expanded to ensure that buffers of a minimum size are required when residential districts abut non-residential districts. So we are proposing that a minimum 3-meter wide buffer be required between residential and non-residential districts.
So a question, Joelle, has some thought been given to the type of plants and the type of landscaping that is occurred at the time of development? Because my understanding, especially in residential area, once the development is complete, then the Town of Cochrane takes over the care of the landscaping and the plants that were there during the development phase. Has some thought been as to how that impacts the fact that the Town of Cochrane needs to have resources to be able to carry those forward? So if there are complex plants and difficult to take care of, I'm just wondering, some thought has been taken into account over time, how much staff time is really going to be needed and allocated to take over these very nice parks that we're putting in.
Right.
Joel, I can answer this.
Sure.
So Deb, I think what you're referring to are the park spaces and our road boulevards and the trees within our road boulevards that the town is required to maintain once they've been developed within a new neighborhood. Is that correct?
It is correct.
Okay. So yes, the types of trees, the number of trees, the placement of the trees, are all they all meet the town of Cochrane standards. There is a process that we go through our subdivision, and even in our neighborhood planning process, where our Parks Department is very much involved with that, and look at the plans that are being proposed and are part of the decision making and approval process. So yeah, and the town does have specific standards in terms of the types of trees, like I said, and so it is already regulated.
Yeah, and it's, I mean, just a comment is that it's a really interesting balance. We love the parks, we love them. I am also aware of the amount of man hours to keep them up. So when there's an extra blade of grass out of sorts. Thank you. There doesn't seem to be any other comments or questions, so you can carry on, Joelle.
Perfect. I think we're going to pass it back to Jill now to continue with supportive housing.
Great, thanks, Joelle. So now while we already kind of touched on this earlier, but this is our slide on supportive housing and how we did put it out for our draft engagement. So supportive housing means an institutional care facility providing residential accommodation in addition to professional care, supervision, and/or medical treatment to 6 or more residents. At least one staff member must be at the facility at all times. Typical uses include, but are not limited to, seniors housing, extended care facilities, hospices, shelters, and other similar uses. It may contain individual dwelling units and/or sleeping units with communal cooking, dining, recreational, and living space. The land use district density regulation shall determine the maximum number of sleeping units permitted in a supportive housing facility. And when a supportive housing facility is comprised of sleeping units or a combination of sleeping units and dwelling units, 2 sleeping units shall be considered 1 dwelling unit. So supportive housing under the draft bylaw is currently listed as discretionary use under CPC's authority in the residential medium density and residential high density districts. It's also contemplated within our commercial districts and within our public service district. So if the town were to develop a shelter on their property or a seniors facility, then it would be listed as a permitted use in that district. Is there any questions related to supportive housing? I know I did kind of start to talk about planning and how we are able to regulate use and not user. And the reason why we did put the engagement out this way and we were trying to be, is because we were trying to be mindful that we currently have this type of housing in our residential areas. They are lower scale, and we wanted to ensure that the ones with more residents in it were receiving the proper or were receiving public looks. And so why we went ahead with this was we were being mindful of the use as opposed to the user.
One question I had, Jill, and just a small question. What is the definition difference between a dwelling unit and a sleeping unit?
That's a great question, actually. So a dwelling unit includes a kitchen, washroom facilities, and a sleeping area. A sleeping unit would not contain a kitchen unit or a kitchen area. So it could contain a washroom and a bedroom. So we're kind of talking about sometimes now or newer seniors facilities, they kind of have those facilities are being built with that transitional housing where you might move into a seniors facility, but it might be set up like an apartment or like a studio apartment. And then you might transition within that same building where you need more care. You can no longer cook for yourself. And so we were just trying to be mindful of that, that when we're looking at density, that, you know, maybe other considerations have to be looked at when we're trying to meet minimum densities if it contains sleeping units.
Okay, so what I just heard is that a sleeping unit, I don't have access to cook. I can't burn the place down. But a dwelling unit would be all contained, like an apartment.
Absolutely.
Okay, thank you. So any other questions or comments on this topic? No? Okay, I think carry on.
All right, so now we will take a look at signs. So we have made some changes to signs and the way that we are looking at regulating them in Cochrane. So what some of the major highlights from this section are that currently we have an extensive list of sign types with overlapping characteristics and ambiguous definitions. So it's been difficult to provide direction to business owners looking to put up signs on their properties. So for the proposed bylaw, we are including new definitions for sign types, which broaden the uses and clarify the different sign types of signs. A new use for specialized signs has been created, which will encompass sign types that don't meet any other definition, and they'll be considered discretionary, just to kind of simplify this section of the bylaw. So one of the important big changes to this section is that third-party advertising will no longer be prohibited in Cochrane. So what third-party advertising is signage, which is advertising a business located on a different property than the sign is placed on. So currently we do not allow for third-party advertising anywhere in Cochrane. And under the proposed bylaw, that regulation will be removed. And this is very important, is we've had a legal opinion provided to us, and other bylaws do not regulate sign content, but it's actually gets into the freedom of speech. And so we're actually not allowed to restrict sign content. So this was a change that was necessary to ensure that we had regulations that were actually legal within the new land use bylaw. I mentioned this previously, but all backlit signs and digital signs will require CPC's approval, as it currently does, as they currently are required. And the lists of development permits not required, I'm not sure if you guys had a chance to take a look at our sign section, but we did try to simplify it a little bit, just by kind of calling out the sign types and saying like a real estate sign, and then saying which ones don't require a DP, just to make it easier for the user and also for the development authority when they're quickly trying to answer a question, or when they're reviewing regulations related to that type of signage.
Okay, so two questions I had with respect to signs. So when I come down the hill on the 1A coming from the south, I think there's a sign that has multiple different businesses on it. Is that what's called a third-party advertising sign? Or do you call that something else?
Are you referring to, is it one of the signs that are essentially like the blue signs that you see that talk about the businesses within Cochrane?
Yes, yes. So is that a third-party advertising sign or not?
Technically, that would be considered third-party advertising. However, it's located within the highway right-of-way. So that's under the jurisdiction of Alberta Transportation, and they don't have that regulation currently. Also, one of the other things to note is that through our bylaw, we can only regulate properties. So we can't regulate roadways. So between a road and a property line, generally there's an area called the road right of way.
Mhm.
That area is not governed or regulated by the land use bylaw. That area falls under our traffic bylaw, and there are different requirements for that space of land.
Okay, thank you. And a second question I had was with respect to sandwich boards, and I wasn't too sure that I had actually read it correctly. So can you just go over sandwich boards and the need for whether or not they need a permit?
Absolutely. So under the proposed bylaw, they do not require a development permit, and we've clarified that under this bylaw. Currently, they aren't exempted, although those generally haven't been enforced on, because we do want to allow for our businesses to advertise. So the regulations within the proposed bylaw will allow one business, or will allow each business to have one A-frame sign on the site. So if you're on a site like up in Sunset Ridge at the Trading Post site, each one of those businesses would be permitted without a development permit to have one sandwich board out.
Okay, great, thank you. And I believe that George has a question.
I think you might have answered it. I was wondering if there's a limit on the amount of portable signs you can have on one property. Last thing we want is to look like a Texas flea market.
Absolutely. So one of the important things to note is, while we were just talking about sandwich boards or A-frame signs, those are just the little guys that kind of flap close. Those are different than a portable sign. So a portable sign, they're generally those larger black signs with the changeable letters that you see. So we do have restrictions on portable signs, and you are allowed up to 2 portable signs on your property, provided that they are spaced out 40 meters, and they're 40 meters apart, regardless of if they're on the same site or not. So we are regulating that. We're trying to ensure that we at least have a separation distance between whether they're on the same site or not. So.
Okay, George, does that answer your question? Yes, okay. I think that that's all the questions. So next slide.
Awesome. All right, so this is actually a newly titled section of the land use bylaw, and at the beginning of our session tonight, I just had spoken about some of our current bylaw regulations and how they are not in alignment with provincial regulations. And so this section essentially talks about special risk lands. So these are lands which there could be some type of risk associated with them. And that's why we've titled it this way. So we've gone through our flood hazard regulations, and we've looked at them versus the provincial regulations, and we brought them into alignment with one another. And so these areas actually appropriately reflect what the provincial regulations are. So development in flood hazard areas are now discretionary. So we want to ensure that they're being reviewed because there really is no other way of ensuring that they're being built up to the flood elevation. So no development may occur in the floodway except for repair or maintenance to existing buildings or replacement of existing buildings, provided flood-proofing design measures are undertaken. And then within the flood fringe, we're including these regulations that mechanical and electrical equipment within a building shall be located above the designated flood level. And all new development shall be located at or above the 1 in 100 year flood level plus 0.5 meters of freeboard. So this is just really important to ensure that if there is a flood, that the damages to the houses will be minimal by lifting your building openings above that flood elevation, and also by ensuring that your mechanical and electrical equipment is above that flood level, so it couldn't be located in the basement of any of these homes, essentially. So some of our other special risk lands that we did identify was adjacent to the railway. So our ops department actually has been working with CP to ensure that our lands located adjacent to the rail line are secure. So now we are requiring for properties adjacent to a rail line to provide a 1.8 meter fence along that portion of the property. These fences are required to be maintained whether there is a development on that site or not. So if the site is vacant, the property owner will be required to ensure that fence is up at all times. And that's for safety factors. And that's actually been rolled out in a number of municipalities. They just want to ensure that people aren't crossing the railways because of the risk that it essentially that could be posed from doing so. Then we're also including a clause that allows the development authority the ability to ask for a risk assessment for lands in proximity to rail lines, gas pipelines, or fire hazard areas. So by including this in the land use bylaw, we will have the ability, if somebody wants to be located close to a gas pipeline, then they have to provide us with the engineering documents saying that it's safe to do so. And that was just an example. Or for instance, the fire hazard areas, they might even have to complete mitigation measures and we would include that as a condition of the development permit, that they follow the mitigation measures of the risk assessment that's been provided. And also with slopes and escarpments. So the language of this section has been clarified. Our current slopes section, it's difficult for anyone to use, even as being a planner for the past 10 years, I had trouble understanding it. So we've gone ahead and clarified it. And then we've also included a requirement for a means of access for the purpose of fire intervention related to a vegetated escarpment. So we just want to ensure that our fire trucks are able to get to these areas and to ensure that they're properly being protected in the event that there is a fire.
So Jill, thank you. So a quick question and a comment. How does the rail requirement for signage play out during as it goes through our downtown? So how do you see fences or meeting this requirement as it goes through downtown?
And that's a good question. So I believe most properties, most of the publicly owned properties have had these fences installed. If there is a vacant property or if somebody proposes development on one of these sites, then we can require this as a condition of the development permit, that these signs or that these fences be installed along those property lines.
Right. So if we get another pedestrian crossway, say across from the hotel, for example, there won't be a requirement, like we won't have to work around a fence there in order to have that walkability piece.
No, if it's an approved walkway, then that regulation wouldn't apply, but we want to ensure all of that they're designated and allocated walkways, that it's not just somebody because they don't have a fence and it's a vacant site. So they're just going to jaywalk across the rail line to take a shortcut. So we just want to ensure that, and we can't go now and ask for that to happen. But if we get a development permit on one of these sites, then that development permit can trigger the use of this requirement or this regulation.
Okay. And then just a question or a comment with respect to the risk assessment. Does that include overhead power lines? Would you ask for a risk assessment in that scenario when they're really close to power lines?
In the research that we've done, I haven't seen that indicated. Generally, if it's an overhead power line, then they'll take a right of way for it. So then you can't have development within that right of way. It's similar to gas pipelines. It's just gas pipelines, there's potential for explosions and that sort of thing. They tend, and the user and what type of, how they're being occupied. So if they're occupied as a residence, then people could be in there longer. But generally those overhead power lines have right of ways kind of protecting the land. And that development can't occur on those right of ways.
Okay, great. Thanks for that clarification. I don't see any comments or questions.
Awesome. Now, Joelle is going to talk about non-residential parking and their parking strategy.
Okay, so before we actually present our new proposed parking strategy for non-residential uses, we did just want to take a step back to look at the system of parking that's currently in place and how it came to be, to hopefully better understand what we're proposing. So in our current land use bylaw, every land use is required to have a set number of minimum parking stalls based on square footage or another measure like number of seats for restaurants or number of rooms for something like a hotel. So parking minimums began being included in most land use bylaws in North America in the 60s when the use of personal vehicles began to proliferate, and they've continued to be included until today, largely unquestioned. So when they were originally included in bylaws, they were based on peak parking numbers. So for example, to calculate the number of stalls for a mall, they would consider how many cars are there on Christmas Eve. These numbers have obviously been amended over time, but because they have been carried over for so long, they are largely arbitrary calculations that in many cases result in an oversupply of parking. So while parking minimums do provide assurance that a certain amount of parking will be provided, there are also some disadvantages. So as mentioned, because there is no universal and all-encompassing formula for calculating parking stalls, in some cases we are overestimating the need for parking and filling space with parking stalls that could otherwise be used for other purposes. We're also reinforcing car use by oversupplying parking, which can discourage the use of other active modes of transportation and transit use. And obviously parking is very land intensive and thus costs money, and that can be restrictive for businesses opening or expanding. So open option parking is an alternative to parking minimums, and this is what we're proposing through this amendment. So open option parking allows businesses to determine how much parking makes sense for their development rather than relying on rates in the land use bylaw. So this approach is obviously much more flexible and allows us to accommodate different contexts, increases the opportunity for small businesses to develop and expand, and help support various modes of transportation and create more pedestrian-oriented environments over time. This does come with a risk of undersupply and potential impacts to on-street parking. However, in nearly all cases, it is in the best interest of business owners to supply an appropriate amount of parking for customers and employees without being bound to a specific number.
Okay, and Heather has a question, Joelle,
Okay.
before you go on.
No worries.
So is this parking plan, is it a blanket parking plan that will address all types of businesses? Or should there be sections based on the size of the business? Like I wouldn't agree that we have over-planned parking for that Canadian Tire. I mean, if you went there on a Sunday afternoon, last Sunday afternoon, you couldn't get it in out of there. So are there different levels? That's the number one question. And number two is, when a business applies for a development permit and they're talking about, this is how many parking spaces I think I need, is there somebody in the administration who is A, guiding them, giving them some direction, and B, who will have some kind of final approval on what that looks like? Does their plan have to be approved? Like, can they say, oh, I think I'm gonna need 3 parking spaces, and then when all is said and done, we can only afford to do 1, or you know what I'm saying?
Right.
Is there a sign off on it? Yes, we agree with this and go for it, you know?
For sure. Jill, actually, if you flip the slide, I think I should address both of your points in the next bit of information. And if I don't, just feel free to jump in. So something that we did want to stress in proposing this is that this will by no means be a parking free-for-all and does not mean that new businesses will be providing no parking stalls or, for instance, 10 parking stalls for the Canadian Tire. So rather than staying completely silent on non-residential parking within the bylaw, as has been done in some other municipalities, we have included a clause that will require applicants to indicate the number of parking stalls they're proposing in their application, along with rationale for why they are proposing that number. We have also included some guiding considerations within the bylaw for development officers who are determining whether the proposed number of stalls will be sufficient, which include looking at the scale of development, like you mentioned, the proposed use on the site, and the parking required by various uses on the site. So this does actually mean that we have a better chance of ensuring appropriate parking in a lot of cases, where even with having parking minimums, you could end up with too few stalls in certain contexts because you only have to meet that listed number in the bylaw. Whereas with this strategy, we can work out hopefully a more appropriate number of stalls. So there absolutely will be someone reviewing and signing off. It's not just I'm proposing 2 stalls for Canadian Tire and that's what's going to happen. Does that help?
Sorry, Heather, you're muted.
Yeah, sorry, I just clicked the wrong button here.
So that does help.
Yes, that helps immensely. I think that knowing that they have to come to an educated and well-informed decision in conjunction with the administration, and that is actually going to get the stamp of approval, and they have to abide by that. And if I've gotten any of that wrong, correct me, please. But that's how I'm hearing it. Is it's going to be a conversation, a plan, and then administration says, yes, we will approve your development permit with this many parking spaces.
Yep, that's absolutely correct.
Hmm. So Joelle, a question. Is there an assumption or underlying assumption that we have too much parking currently in Cochrane?
Definitely not in all cases, I would say. I think in some of, I don't know, Riley or Jill, if you want to jump in some of our newer commercial areas, there has been a tendency to oversupply.
Okay.
Yes, that is correct, Joelle. I know that there are some businesses in Cochrane that apply their own parking standards that are over the parking minimums that are established in our land use bylaw currently. So we are aware of those areas, and they do that purposely for their business cases. So so in some areas, yes, in other areas, less so, certainly.
So I believe there was a parking study done, and I'm just wondering from that parking study, and I'm just clarifying, was there an assumption that there's too much land allocated to parking within the downtown area? And that would include everything from Griffin down to north to Highway 1A between Fifth Avenue and Center.
So that parking study that you're referring to was for the historic downtown. It wasn't for the all of the downtown. That included the lands south, including Fifth Avenue, and south to Griffin, including the quarry. It was for the historic downtown. So very broadly, the conclusion of that parking study was that there was ample public parking available downtown in the historic downtown, and so that parking study was just specific for that area and was conducted over different days of the week and different times of the day, where they went out and they recorded all of the public parking stalls that were being utilized throughout that period.
Okay. I personally would question the results of that, and that's just because I'm a business owner on the corner of First and Fifth Avenue. No, sorry, First and Center Avenue. And frequently the building that I am in, there's insufficient parking. And the interesting thing is that when that parking lot is full, there's nowhere else for people to go. Other locations such as the Royal Bank and the Home Hardware have very much stipulated that other people should not be parking, just their clients, and there really is nowhere else to go. And so as I think about going forward and the amount of tourism that we want to encourage and the amount of walkability, so less people coming into this historic downtown, I really think that we need to think about having designated parking areas, maybe two of them that are at one end and then the other end of the historic downtown, so that we can encourage that behavior. We encourage people to park there and then to be able to walk. But if we don't do something about that now, I'm not too sure that we're going to be able to encourage the walkability, which is where we really want to go at the end. So that's a suggestion, just something to look at. The other thing I'm a bit concerned about is the change of use. So even if you could take the building that I am in, over time, the people that are renting from that building has changed. And with that, the parking requirement has changed substantially. And so my understanding is if we determine that this particular business with this particular use requires this many parking stalls, that stays with that envelope, so to speak, forever. And the parking changes might need or change quite drastically. So I don't know how you address that possible expansion of parking needs over time.
I think one of the things to consider in regards to that is that the businesses choose the location for different reasons. And one of the reasons when they're making their choice of locating within a particular lot or within a unit of a particular building, I think they do consider parking and the existing parking in relation to their business and their business needs. And so part of that is the free market and the business case for each individual business when they're determining their location. So I do understand your point, but that is something that I think the businesses do take into account when they're locating.
Well, yes. However, I think most businesses would like to be in historic downtown, especially as we evolve and we get high traffic area. So they might turn a blind eye to the fact that they don't actually have enough parking for their customers. So I'm just flagging that as a red flag. The other thing that has been discussed over time, contemplated maybe at a very high level, is that there are times when that First Street will actually be closed due to events or to promote increased walkability. There's been discussion about maybe even running buses now that we have buses rather than all the parking. So in that case, if any of those things were to come to fruition, then I would suggest that there is insufficient parking down in the heritage area myself. Just my comment. And I think that George also has a question.
I think my question has been asked and answered, so I would draw it.
Okay, thank you. Are there any other questions or comments on this piece with respect to open parking? Okay, there doesn't appear to be any.
Perfect. So lastly, the only other thing that we wanted to note about this is that we are by no means the first municipality to propose this change. Many cities and towns throughout the States and Canada have begun moving in the direction of reducing and eliminating parking minimums, with a few prominent examples being found here in Alberta. So the city of Edmonton approved the removal of parking minimums for both residential and non-residential uses last summer. High River has a new bylaw that eliminated parking minimums. Medicine Hat has eliminated parking requirements for some non-residential uses. And the city of Calgary recently approved the same change we are proposing by eliminating parking requirements for non-residential uses only.
So again, a question I would have is, how does this align with the vision of council with respect to creating a Western Heritage historical area where walkability and access is of prime concern? And so, I mean, I appreciate that other places are doing that. I guess the thing to look at is, do they have an area such as our Western Heritage area that we want to become the centerpiece of the jewel of Cochrane, and would they have done it in those areas? So I'm just not too sure about if we're comparing apples to apples.
Actually, Jill, I might ask you to comment on that, given your experience in Medicine Hat, specifically with their downtown, and how the elimination of parking requirements there has worked.
Absolutely. And so I guess before I kind of get into that, one thing I did want to reiterate is we aren't removing the requirement for parking stalls in non-residential areas. We are just removing the numbers that we prescribe for parking stalls. And we're saying when you apply for a development, you'll be required to submit along with your application your parking stalls that you are proposing for your site and a rationale why those parking stalls are sufficient to serve your development. I just wanted to clarify that part. So Medicine Hat actually a number of years ago removed their regulations related to parking in a number of their districts, including their downtown. If anyone's familiar with Medicine Hat, they too also have a very touristy area that's known as the Historic Clay District. So it does attract a number of artisans to that area, or artisans. And so what had actually happened is there was a number of new developments that we saw going up in the downtown, and really the parking situation there was not an issue because the parking regulations weren't, because there were no parking stall requirements. Business owners were still providing parking on their sites because otherwise it would impact their business if they didn't provide for them. There was still ample on-street parking provided. It just allowed for some redevelopment within that area. They also had it within their mixed use district, which kind of helped this. It's kind of more of a transition between residential and commercial, that kind of helped promote that district and the use of it. And we kind of saw developments start to occur that were, more pedestrian in scale and were more walkable. So they're the municipality that have actually had it removed for the longest. And so, of course, places like High River, City of Edmonton, City of Calgary, it's probably too soon to tell because these are recent changes. However, the way that they're being prescribed, it just allows for consideration. We were talking about this earlier in the day, Joel and I were, and we're talking about how through the land use bylaw, we could require, and I'm just going to throw out a number, we could require 2 parking stalls per 100 square meters. And then we might have a business owner come in and rely on our parking stall calculation when, if they were to come in and actually consider it, have a designer lay out their site, maybe that designer would have been said to them, well, you're going to need 4 employee parking stalls, and then you can anticipate to have, potentially 10 people and vehicles there at a time. We might actually get more stalls on a site rather than them relying on our minimum parking stall requirements. So that was just kind of one of the conversations we've had about it. Of course, it's a new concept to many municipalities.
And I'm not against the concept. I'm just trying to figure out how to play out, especially as uses change over time. So business A might need 2 new parking stalls, but business C might need 10. So, and how do you deal with that? And I do remember one development permit that came to us where it was commented that they wanted us to do a significant variance of less parking stalls, and the statement being at the time, well, people could park elsewhere. So, I just want to be really, this is a significant issue, and our downtown is a huge development opportunity for us. So I just want to make sure that we're being as visionary, I think, as possible to make sure that let's make it easy access for everyone. So
I just want to make one more comment about the historic downtown, and I do appreciate your comments about it being an important aspect of Cochrane, part of council's vision. We were very mindful of that when we were considering this change, and we do realize this is a significant change. But we're being very, very mindful of the historic downtown. And to your point that you had just made about accommodating and ensuring that the downtown is vibrant, that it has businesses, that businesses are able to locate down there. Currently, one of the greatest deterrents for businesses in our downtown is our parking requirements and our parking minimums. Given the lots and the extent of the existing development on those lots, and the amount of area that's available for parking, many new uses or new developments cannot meet our parking minimums. And so as a result, they may not be able to locate in our downtown. So this actually encourages businesses to locate within our downtown. And that was something that we were very, very mindful of.
Yeah, and I fully appreciate that. I did like the suggestion of perhaps a parking levy, or I'm also just thinking about like a designated parking area in lieu that all of the businesses could contribute to. And then when we have a change in land use, then you could look at what their contribution is and maybe reevaluate at that time, and maybe higher or lower their contribution depending on what the new use is. So that's just a suggestion, because I mean, I did like the discussion point, or at least open them up with respect to levies to a parking area.
I'd just like to make a comment as I'm listening to this, that isn't the historic downtown parking issue more of a municipal development plan issue than a bylaw issue? And it should be looked at a bigger scale than doing this to individual business owners, but look at it on the scale of what Deb was referring to, that maybe we do need municipal parking at either end of the downtown to promote pedestrians. So I don't think it belongs as a bylaw issue. This is my comment.
Okay.
No, thank you for that, George. I can comment. I can comment on that just to say that you are correct. It is both. It is both the long-term planning for the historic downtown, absolutely, and how we're planning for that in the short and long term. But currently regulating parking is an aspect of the land use bylaw for each individual parcel and proposed development. So it is a mixture of both.
Yeah. So thanks for bringing that up, George. And it is, right? It's kind of long-term vision and land use at the same time. So I believe Heather has a comment also.
No, actually, you guys covered what I was about to say, so we can keep going.
Okay, so I think I think we've got everybody. So carry on. We've got our comments.
Awesome. So this just takes us to our next slide. So what's next in the project? So we're currently reviewing comments and making edits to the draft bylaw. So we will be looking for your comments based on our discussion and your review of the council workshops and the parking lot session that we did have. So we are looking to complete that between June and July. We're hoping, although this is not set in stone yet, but we're hoping for the adoption process to begin in July, and hoping that by September that we have the new bylaw adopted. And then once the bylaw is adopted, we'll start our implementation review and monitoring program, which will include us tracking complaints, variance requests, and a number of different issues that we are noticing in a new bylaw. Of course, our existing bylaw has been in place for 17 years now. And while we are trying our best to ensure we have all our T's crossed and I's dotted, with a new bylaw, there is potential for there to be some issues that arise. So we'll be monitoring that for a year, and then we'd hopefully bring a comprehensive amendment back within a year to make edits and changes to the newly adopted bylaw to ensure that it remains current and effective. And that's all that we have today for you guys. If you guys had any further questions or discussions or anything that you guys would like to note, please feel free to do so.
Okay, well, Heather has a question, and then I have a question. So Heather?
So I just have a comment, and my comment, Jill, is that you continue to amaze me with the amount of knowledge that you have. You're like the planning encyclopedia. You just flip through we'll call it the Jillopedia. You just flip through, and I mean, you're right there with the answers, and it's very impressive, it really is.
Thank you. Yeah, I spent a few years in a few different municipalities, and you have to learn quickly when you're a brand new junior planner and a manager of planning all at the same time. So thank you. I really appreciate that.
That's what they call a stretch assignment, Jill, when you're doing that. So the question I have is, so there was and council went through a number of workshops and went through a parking lot, and you've received some of our questions and comments related to that. Now can I just clarify, is the door still open to hearing more of those from CPC members on an individual basis, or what do you see, or how do we proceed from here?
Absolutely. So of course, as CPC, we'd like you guys to provide your collective comments. While our online engagement has now closed, we could allow for your comments to be added to our What We Heard report as individual comments. Of course, we'd hope for your guys to comprehensive comments to kind of come together. So what you guys are making, your comments that you're making together as the commission in one document. And if there's something that you'd like to add individually to the What We Heard report, of course, that What We Heard report will be anonymous, and it won't be presented in a way that, Heather from CPC said this, because as the commission, you guys are providing us your comments.
So I'm just trying to think this through, because I don't really have the answer, but very specifically in the parking lot, there was a number of specific issues, such as rear yard setbacks, that today, because we didn't discuss them today, you don't have a collective comment or set of comments from CPC. So this is a little bit of a unique space that we're in. So I'm just wondering how we best manage that space, right?
For sure. And so I guess what I can do is I can provide you with the parking lot items just in a list, and maybe just a brief description under each one. So whether it be just the reduction of the rear yard setback from 7.5 meters to 6 meters, and then for residential areas. And then if you guys wanted to provide your collective comments on each of those, we can do it that way.
Deb, sorry, Jill. Deb, if I may make a suggestion.
Absolutely.
I think you started a document there that you circulate to us in regard to some of your comments. I think that what we should do is I'm recommending is that we each provide comments back to you as a central person as part of the committee, and then collate that together and see if we can have a consensus of what we send forward to administration. So that way you get all our comments sent to you. We see where there's agreement among us of what those comments should be, and then have a one position as a CPC and then send it on to administration.
Okay.
If you can give us a timeline of when you want those comments for, therefore we have a
Yesterday.
deadline.
I want them yesterday.
To allow you guys the ability to kind of collate your comments, we can allow you guys until next Friday, but we're kind of at a hard stop for then. We were hoping to get our what we heard report posted ASAP so that council can start looking at it. So while that, as individuals and as residents, you had that opportunity for comments was available, we can allow you guys some additional time on that, but we'd hope to have your individual comments. And keep in mind, these will be anonymous. They are not being presented as commission members, included in our what we heard report until this Friday. We'd really like to have this out to the public as soon as possible. So if everyone thinks that is possible.
Yeah. I don't think that, I think that more than anything, we want to be able to just get our collective, well, I don't want to say agreement because we may not agree on things, but our collective statement to you guys to review. And so I think what George said was great. And just use that document that Deb already made. We send our stuff back to Deb. She can ask us questions. Now, what did you mean by this or whatever? So like, let's say today's Wednesday, we could have our collective comments or our individual comments back to Deb by say Friday, this Friday. And then maybe we do a review of, Deb has time to have questions. We do a review of the final, say by next Tuesday or Wednesday. And then we as a group agree that this is okay and we send it on to you guys. That's a week.
Yes.
So.
And, I'm very cognizant and appreciative of the timeline with the planning department, and you really need to get things done. So I don't want to elongate it too much. The other thing is I do want to clarify in that document some of the language, because when I rethought it, I thought the language didn't land very well. So it's not our job to recommend to council. We can make a suggestion to council, or we cannot direct council to do. We don't have that authority. So my language was maybe a little bit stronger than I meant it to be. So just take that with a grain of salt. But I would, so if I could get everybody's comments by Friday, then that would give me Monday, Tuesday to look at, ask any questions and put together a draft so that we can at least get it back to planning department by Thursday.
Yep. Yep, that works for us. So then in the meantime, we will get our what we heard report posted, and then the planning commission, like we will post the link to the meeting on our Let's Talk page. And if somebody would like to tune in and see kind of the outcome of this meeting and how our discussion went, they can check it out. Yeah, thank you guys.
And I think just one thing, and yes, it's okay for us not to all agree. It's not about us, for us all to be exactly on the same page. I know in previous discussions with Mayor Janung, he wants to hear all the voices. So, okay.
Madam Chair, if I can, I thank you for bringing that up. I was going to raise that as well. It's important for the members to know is that you don't all, it doesn't have to be consensus. No. You don't all have to agree, but the process you've laid out is really good. And might I suggest, I think for Jill and Joelle's benefit, I know, Jill, you had offered to outline each of the specific items in the parking lot. That information is available through the videos that have been provided. If we can just save that task for Jill and Joelle, and but offer, if you have any specific questions about any of the items that are listed there, please do feel free to reach out to us and we can clarify any of the information.
So Riley, just to clarify what you just said, is that we're going to spare them from that task. We can watch.
That is my ask. Yes,
Okay.
please. But
All
but please do reach out if you do have specific questions. Yes.
Okay, perfect. And Mayor Janung, would you like to say something?
Yes, thank you. I've been sitting so quiet for so long. It's so unlike me. First of all, I just want to say thank you to all of you guys for all of your hard work. This is obviously a huge document with huge implications and impacts in our community. I just want to say thank you for taking such a in-depth dive into our land use bylaw draft. And I echo, Heather, your comments to our team. I've just been so proud and happy with all of the efforts that the planning team has done throughout this journey. I think the look and feel of the document, in my view, is well above and beyond expectations of council, that's for sure. And community feedback I've been hearing so far has been positive. I just would stop for a moment on your parking lot items that council highlighted. We did have quite a lengthy list, but we also worked through that list in that one last video, and we ended up with really, I think, out of the, 15 things that we identified through our workshops, we got down to, I'd say, a handful by the end that really we just were looking for clarification on. So it's not really that huge, daunting list that you might be expecting. It's really just a few things. And I was just going through my notes while you guys were talking, and it's really, I think you've already had that discussion for most of it. So yeah, thank you.
Yeah, so thank you. And I think just building on that too, I mean, my document brought forward what I thought were the main issues. And so you may have something else that you want to bring up. So don't limit yourselves to just those things. You've listened to a lot of the workshops, and this is as I say, this is a collective and comprehensive voice. So just because those are the ones that I thought were issues, please don't not comment if you think that there's something that we need to add. Okay, is there anything else? If there's not, can I have a motion to end the meeting, please? Everybody, and the meeting is adjourned, and we are 6 minutes under time.